For those of you who don't know me, my name is Jay Sturm, and I am the founder of Cranes 101 and Cranes Aerial Truck Service. Jennifer, my daughter, who now is the president of that company, is sick with the flu and couldn't make this. She's really heartbroken over that, I can assure you. This is going to be enlightening, I believe. This topic is a very volatile one. I don't know, how would you describe marijuana in the workplace? I'm going to call it volatile. It's something that has affected us and our company, and I think it's likely could affect anybody in any company. There's a lot of unanswered questions since Massachusetts has decriminalized the use of marijuana. There's an awful lot of questions that I know I have, and I'll bet you everybody out here has. So I'd like to get to that very quickly. This is going to be an open forum seminar, so there's no prepared presentation. This is all going to be Q&A, only because I know the Q&A is going to be very heavy. Without any further ado, I'd like to introduce our panel. We are so intensely lucky to have these people here. You can't imagine how excited I am. First off, the far end is Maria Sturm. She is the Human Resources Director at Cranes 101 and Cranes Aerial Truck Service. So she's going to opine on her perspective. Next in line here is Matt Fogelman. Matt Fogelman has now become a famous attorney here in Massachusetts for trying and prevailing in the very first marijuana case that has happened. And I know Matt is going to give us a little bit of a blow-by-blow as much as he can. Dr. Noelle Woolley from the Laborers Union is also here, and she is going to put in from the medical perspective, which I know we really need. I know I do. So we're very lucky to have her here. I want to thank you for coming here. And Michael Clarkson, who was on the same case as Matt, but on the other side. So Matt is going to be representing the employee side of this marijuana case, and Michael's going to be representing the employer side. So I would say that we could throw employer questions in one direction, employee questions in the other direction.
I was the Falcons. We were up 28-3.
You said it, not me, right?
I like it right up until then.
Well, this is a good example, though, as we were saying before, of attorneys who are on the opposite side of a case, but get along very well and have a good rapport. And, you know, it doesn't have to be nasty, you know? Yeah, everyone's representing their own side and doing 1,000%, but we respect each other and we get along very well. And so this is a nice example for those who wonder whether that's possible. It is possible.
It is in fact possible, and
Hence, that's why you have a doctor in between them.
I noticed that.
We have medical here.
Well, so without going any deeper into that, I'd like to call on Matt first, if you would, and explain what you can about the famous Barbudo case. I got the name right, didn't I?
You did.
And maybe we'll start there, and then and get opposing views and opposing sides on that case, and then we'll take it from there. We'll take the floor.
Sure, absolutely. Okay. So good afternoon. Thank you for coming today. I think this will be really great. So as Jay said, my name is Matt Fogelman. I'm an attorney. My office is in Newton, not too far from here. Happy to give out my email address and phone number afterwards to folks. And I mostly handle employment cases and personal injury cases. On the employment side, I represent people, usually employees, usually the workers. I do some behind the scenes consulting and advice for companies, but as far as actually with a case, bringing a case forward, it would typically be for the employee. and all types of discrimination cases, sexual harassment, which is very timely right now, and everything in between as it relates to employment, non-compete agreements, severance agreements. So this case came to me a couple of years ago. A woman by the name of Christina Barbuto came to see me. And Christina, I'll just give a very brief overview of the case and sort of how the case came to be. She suffers from Crohn's disease, which is a very serious gastrointestinal disease. She's very thin, it's hard for her to keep weight on. And she had a certification. And I'm sure Dr. and Attorney Clarkson can speak about this as well. But in Massachusetts, as of a couple years ago, with medical marijuana being legalized, one can obtain from a physician what's called a written certification. It's not technically a prescription. I think a lot of people, just in layman's terms, call it a prescription. It's actually a written certification. For all intents and purposes, it's quite similar to a prescription. In any event, she had that. She had sometimes what people call a card, which would enable her to legally obtain and use marijuana for medicinal purposes. One thing to keep in mind, this has nothing to do with recreational. And we're happy to talk about recreational use today, and it might be quite pertinent to talk about it, but this particular case does not have anything to do with recreational use, nor does the Supreme Judicial Court decision have anything to do with recreational use. Christina had applied to work at a company called Advantage Sales and Marketing, a California-based company with a Boston office. Attorney Clarkson represents Advantage Sales and Marketing. And the job that Christina was applying for was essentially a desk job. It was a marketing job. She would stand in the grocery store and do promotional, hey, does anyone want to try this new turkey or whatever, that type of thing. As part of the application process, she was told that she was going to have to take a drug test. She advised the company, a lower level person, that she had Crohn's disease, that she legally used marijuana for medicinal purposes, and would that be an issue? She says that she was told that it would not be an issue. She took the test, which was a urine test. She went to work. She worked for one day and then was terminated after one day because she failed a drug screen. She was surprised at that and not too happy, obviously, and tried to say to the company, well, but I told you I was going to fail, and I was told it wouldn't be a problem, and I use it for this medicinal reason. And they basically said, well, sorry, but that's the way it is. I think it probably went up to a higher level of the company. Maybe Mike can talk about that a little bit. In any event, she came to see me, and I teamed up with another attorney, a guy by the name of Adam Fine, who I don't think is coming today. And we filed a case for Christina, which went through several iterations. The thrust of the case was a discrimination case under Massachusetts law, what we call 151B, which is the employment discrimination statute. And that protects employees against any type of discrimination, typically race, gender, religion, age, sexual orientation, and medical condition. Those are sort of the big six. And so we alleged that the company had discriminated against Christina because of her medical condition. Her medical condition requires her to use this medication, and in our view, she should not have been fired for that reason. We were at the lower court in Massachusetts, the Superior Court. We also had another claim, because this may come up as part of a question. We had another claim for invasion of privacy, which has nothing to do with the disability. It has to do with whether the drug test itself was proper. And I think Mike and I probably have some different views on that. But we had that claim as well. And in my view, in certain industries it may make sense, and some of the industries that you folks are in, it may make sense why you need to do it, and in other industries, I think it doesn't make sense, and I think it's considered an invasion of privacy, and I would argue that a desk job or a marketing job, they shouldn't even be drug testing to begin with. Again, there's different views on that. So in the lower court, what's called the Superior Court of Massachusetts, we're before a judge named Judge Tachka. He dismissed, Mike brought a motion to dismiss the case, which is basically a early motion that one can file in court to try to get rid of the case. Case shouldn't go to trial, it should just be thrown out essentially, because it's not a case. It doesn't rise to the level of what could constitute a case. And the main reason that was advocated was that it's illegal under federal law, and the accommodation she was seeking was basically to have the test not apply to her, and that wasn't in and of itself could not be considered a reasonable accommodation. The judge dismissed the claim, did not dismiss the invasion of privacy claim. Let's put that to the side for the moment, although we can definitely talk about that today if people are interested. We then took an appeal. Normally you would go to the appeals court and then up another level to what we call the SJC, which is the Supreme Judicial Court, the highest court in Massachusetts. There's a mechanism by which one can bypass the appeals court and go straight to the Supreme Judicial Court. The SJC has to accept that case. It's not just up to the attorney. But we asked for that because we thought that the SJC would be interested in the case, and we were right. So they took it. So we bypassed the appeals court, went straight to the SJC, briefed the case in writing, and then had an oral argument in March, me representing Christina, Michael representing the company. We had a spirited, good oral argument in March, and then the decision came down in July from the SJC. I think some of you may have read it. I'm happy to circulate it later. Forgive me, I didn't bring copies of it, but I can easily email you the decision if you're interested. It's a good read. And basically the Supreme Judicial Court reversed the lower court, finding that the claim should not have been thrown out. One important point is the court, we have not yet won the case. The case is actually continuing. And I think I can say what we're doing with, you have no problem with that, right? So we're actually taking the case to mediation in January with a mediator, and we're hoping to resolve the case. And if we resolve the case on terms that make sense to both of us, then the case will be over. So there may be a couple of things about the case that we can't talk about because the case is actually ongoing. There may be some things that I can't talk about, maybe some things that Mike can't talk about. We can be pretty candid about a lot of things, but if there's some things like that, you'll have to forgive us and understand that the case is still going on. So we can't be as candid as we would if the case was actually completely over. In any event, so we haven't won the case, but it was a significant decision for a lot of reasons. Mainly the SJC saying that the case should not have been tossed out, the case should be allowed to proceed. You may win, you may not ultimately, but you're allowed to proceed. And the reason why that's significant is that what the court was saying was that if you fail a drug test, if you're using marijuana for medicinal purposes and you fail a drug test, you're not automatically dead. You're not automatically dead in the water. And that's basically what the lower court said, right? Essentially, you don't have a case. You can't even bring this case. So the SJC has disagreed with that. Again, highest court in Massachusetts, and they said, no, you can, under certain circumstances, you can bring that case. You still have to prove your case, you still have to win your case, but you can bring the case. And significantly, that the company has to engage in what's sometimes called the interactive dialogue or the interactive process or an analysis, that the company is obligated to engage in a conversation with the worker about what's going on, why are they taking this medication, what is it for, is there possibly another medication they can take? And I'm happy to get into that later too, because I think there's some lines that the employer shouldn't really get into, because I don't think it's their purview to get into the patient-doctor relationship, which is a sacred relationship. But the court, in the decision, raised some possibilities of things that could happen under different scenarios. And in this particular case, the company and Christina, there was no interactive dialogue or process to speak of. They just simply fired her. And the court said, my interpretation of what the court said is you can't just do that. You have to go deeper. Also calls into question the type of industry, as I said, and what may be okay for one industry may be completely different for another industry if public health and safety is involved, so it gets quite nuanced. I think I'll probably stop there. I think it's a good overview, kind of brings us to where we are right now. Obviously, Mike, add anything you want, or maybe where we go from here.
Let me I'll rewind the tape a little bit pre-Barbuto and then talk about where we go from here. And
Sure.
You guys must have questions. Heading into the Barbuto case, there have been, I think, 7 other state Supreme Courts or high-level courts who had ruled on medical marijuana in the workplace. None of them had gone for the employee, including California, which seems to always go for the employee, and including Colorado, which is sort of the epicenter of marijuana, right? None of those states, and if you think medical marijuana is a creature of statute, right? Here it was a ballot initiative, but some other places it's been statute. The statutes break down really into 2 types. You have those that are decriminalization. The cops can't arrest you for smoking pot if you have a card. You can buy pot if you have a card. You can use it. But they're just criminalization statutes. Okay? Then there were 11 statutes, including Rhode Island, Connecticut, and Maine, surrounding us, you're in Rhode Island, which have anti-discrimination provisions in them, which provide some limited job rights for people. Okay? Massachusetts, by the way, was not one of those states that had an anti-discrimination clause in it. So, like I said, feeling like the Falcons, heading with a 28-3 lead, being like, okay, these other states had rejected claims like Christina Barbuto's, and they had been in states like Mass that didn't have these anti-discrimination provisions. So feeling like, okay, we're more analogous to California, Colorado, New Jersey, New Mexico, all these states, okay? That's where we were heading in. Now, there are other decisions. Connecticut and Rhode Island have both come down on behalf of the employee. I don't think they're newsworthy, but they're not nearly as newsworthy as Massachusetts because those states had the anti-discrimination provisions, okay? To be a really quick snapshot of the Rhode Island case, a Rhode Island School of Design student who had migraines and had a medical card went in and applied for an internship, and they pulled the job offer and said, no, we don't allow that here. Well, she had the protection of the statute. So when they found for her, I didn't find that at least particularly surprising. Massachusetts and Barbuto, I thought was more like California, Colorado, New Jersey, New Mexico, et cetera. I thought we were doing well. We won, as Matt says, we won at the trial court level. So we head in the day before the oral argument. The Massachusetts Commission Against Discrimination put a 60-page amicus brief in support of Ms. Barbuto, saying that the employer, my client, failed to accommodate her disability. And the court was clearly focused on that. I was told I'd have 15 minutes of oral argument. I was up there for 25, and every question came at it from this disability discrimination angle. That was clearly what the court was focused on in the argument. That's where they came out with. And Matt's right. The takeaway for you all is that you can't simply say it's a decriminalization statute, it's illegal under federal law, and refuse to engage with the worker about their disability, the accommodations, etc. Okay? Let's talk about that though, because, and excuse me if I sound a little, this decision drives me crazy on some levels, and as you dig into it, I think it'll probably drive you crazy too. This is the first time that the court has looked at a disability, not at the underlying disability. We weren't talking about Ms. Barbuto's Crohn's disease or her appetite. We were talking about her medication. An argument I made, I wasn't successful, but an argument I made was we don't talk about insulin, we talk about diabetes. We don't talk about, pick your medicine. We talk about the limitations that the impairment causes. But here, they focused on the medicine. So this changes the typical disability interactive dialogue now, right? We're not talking about her ability to maintain a healthy weight and her appetite and whether or not we could give her breaks to eat. We're talking about the fact that we have to accommodate her medication. That's new, that'll be a challenge to you. But what's likely to be a bigger challenge, I know there's some people in HR in here, must be what you do a lot. A bigger challenge is when we do the interactive dialogue and it requires us to talk to a doctor. Let's take an easy one, a back injury, and you're talking to a neurologist. What's the person's lifting capacity? Can they climb up into the crane? Can they walk up the ladder, right? Can they work on their feet all day? Well, there are limitations. Oftentimes you have to talk to the doctor. Is this permanent? Is it temporary? How do medications affect it, right? What can they lift? Maybe we send them to work hardening, all this kind of stuff. Trying to do this in a medical marijuana context, I predict, will be extremely challenging. Okay? Ms. Barbuto went to an outfit that only provides medical cards. And she's not alone, that's how most medical cards are issued. A place called Canis Care, what do you think they give out, right? Okay? That's what they're in business to do.
Cans?
Canis Care.
Well, I think about cans.
Not cans.
Oh, okay, sorry.
They might give it to you. Even if you got the doctor at Canis Care to answer your call or to respond to a letter, which is a big if, they're going to say, oh yeah, I found the person to be a qualifying patient. I gave them a card. Well, what do they use? Oh, I don't know. How often do they use it? I don't know. How potent is it? I don't know. Right? And they don't know. They're not playing games with you. They give a card. You take the card down the street to Patriot Care, right around the corner from my office, and that's a retail operation. It'd be like calling up a barista at Starbucks and saying, how much caffeine did the person get? I don't know. Right? They pay cash. Does sour diesel today, is that the same potency sour diesel is next week? I don't know. Do you? No. Okay, even if you did, how much do they use? I don't know. We just sell her a bag of weed. She smokes it whenever she wants. So if you go into a doctor and they give you insulin, they say, take X amount of insulin every day at a certain time, and then you're going to come back in, we're going to test your levels, we're going to talk to you about your symptoms. That's an entirely different protocol than marijuana. Okay? And I certainly don't blame Ms. Barbuto or Matt and Adam, right? And in fact, this is probably an outgrowth of that we classify marijuana as a Schedule I drug, which means the academic researchers out there and the drug companies, they haven't been allowed to, or at least not easily, to test marijuana the same way you test insulin or Lipitor or Ritalin or OxyContin or anything else, traditionally FDA-regulated drugs. But the SJC seemed to have less appetite than I wanted them to dig down into this and to think about what you all as employers are going to have to wrestle with when somebody comes to you. And many of you are in very safety-sensitive jobs. Now, Ms. Barbuto was a perfect plaintiff. It was about the least safety-sensitive job you can imagine. Right? She's demonstrating deli products in the market. She was the perfect plaintiff to tee this up. But somebody who is in construction, somebody who is in transportation, somebody who is running a forklift, who is working at heights, who is working with fall protection, right? That's a very different animal. And you are going to have to grapple with this. All we have now is this one decision with all of its conundrums and unanswered questions, okay? Give you one sense of it. This is the decision here. I'll just read from it. I'm not going to read a lot because that would be boring. Where, in the opinion of the employee's physician, medical marijuana is the most effective medication for the employee's debilitating medical condition, and where any alternative medication whose use would be permitted by the employer's drug policy would be less effective, an exception to an employer's drug policy to permit its use is a facially reasonable accommodation. Well, isn't that interesting? I wonder where they pulled that from. Can you give me another example of where the HR is looking at what is most effective medication? What is less effective? No, we look at limitations, but now we can't, at least when it comes to marijuana. So you're going to have to grapple with this and perhaps discuss with your people what's more effective, less effective, least effective. And, as Matt says, this case isn't over. My motion to dismiss was flipped. If we don't settle it at mediation, we're heading to discovery. And I'm going to talk to her doctor. Did you address other medications? She has Crohn's disease, which impacts her appetite. Was she prescribed Zantac, where she prescribed a steroid to stimulate her appetite, which is more effective, least effective, okay? We may retain medical experts to talk about all of that. If the case doesn't settle, maybe we'll get a published decision out of the lower court which answers some of these questions. But if we don't, or we don't get a published decision, or we settle, somebody someday, somewhere, will start to answer these questions. But in the meantime, you all are left to grapple with this and trying to understand it. In the blue folder is this, and this, I know there's safety people in the room. There's not a lot of good literature on marijuana and safety, unfortunately. That's probably, again, because it's a Schedule I drug and it's so difficult to get it, research it, right, that people don't. This is the best I've found on that question. And there's a lot of stuff in here which has nothing to do with that. But if you look beginning on page 5, health risks of marijuana. It's not health risks, well, it does discuss that marijuana has got more toxins in it than tobacco smoke, but that's not what, at least what I'm focused on. But it talks about the safety implications of marijuana. And you know, the high from marijuana lasts 4 to 6 hours. The safety implications last for days. Days. So you all in safety sensitive spots need to pay attention to this. I wouldn't claim to tell you how to balance these risks of potentially facing an employment suit versus facing a catastrophic injury, but you got to pay attention to this stuff and try to balance it as best you can. Matt's right that Advantage Sales and Marketing didn't do this stuff, right? They didn't engage in a dialogue with Ms. Barbuto. And I think you all should. Where that dialogue comes out, I think you have to be open to listening, talking to the doctor if you can get him on the phone, right? And figuring these things out. Had Advantage Sales and Marketing done that, right, and gone through a lot of steps and even reached the same result. We've talked to you, Ms. Barbuto, we don't think that you can do this job safely because of your marijuana use. They would have had better facts. I don't know if we would have won the case, but those facts would have, I certainly would have made something of them. Right? You should do that. I'll give one example that'll put the point on it, then I'll be quiet. It's hard for lawyers to be quiet. This will sound like I'm talking out of school, but a client of ours said this at an event just like this, and I think it's so useful. I've mentioned it a bunch of times. Boston Scientific makes implantable medical devices. They make heart stents. They make vaginal mesh, things that are implanted in the human body. They had a guy there with glaucoma, okay? He's got a medical marijuana card. He wants to smoke pot. He is in charge of sterility control. Whoa, right? A lot more safety sensitive than Ms. Barbuto asking if you want to try the new boar's head turkey. And Boston Scientific says, no freaking way, right? I don't care, Mike, what you tell me about the employment law risk. We're not letting this guy do sterility control. The product liability suits that we face if a heart stent isn't sterile make the employment case look like a rounding error. Like, okay. I said, I hear you, and I know where you're going with this process, but trust me, let's do the process. Let's talk to this guy, let's talk to his doctor, let's figure out what he uses. Maybe it's temporary. Maybe you can give him a leave while he gets off the pot and onto something else. Let's just talk to him, if nothing else, to just hopefully make a better chance on the lawsuit. Will you go with me there? She says, sure. We start talking with the guy. Get about halfway and got, hey guy, I am reporting to so many people on this one. I've got safety, I've got security, I've got legal, I've got HR. They're all on these conference calls that are making my head spin. We get halfway through the process. What does the guy say? I don't need to use marijuana, folks. There's lots of drugs I can use. I'll just use something different. Right? Why do I bring that up? Because you should engage in this dialogue too. You don't know where it's going to end until you get there. Now, even if they had gone all the way to the end and this guy insisted on using pot, and they said, we just can't do it, I would have had a much better case to defend than I did in the case with Matt, because they didn't do this. At least that's the allegation in the complaint. They didn't do this. So I encourage you to do this dialogue, even if, you know, we talked about a bridge builder, a crane company. You may be pretty sure that at the end of the dialogue you're not going to say yes. Keep an open mind, do the dialogue, if for no other reason to reduce your risk of suit, but you also may find an alternative accommodation, something, okay? So I'll leave off there.
Can I throw a question in before I forget? You just clicked on something that I don't want to forget to bring up. You said that the safety risk from the use of marijuana could run 4 days. That's a medical fact?
It is a medical fact. So usually, if the patient is smoking marijuana, and I'm not really sure what Mrs. Barbuto was. She was smoking. So, and I believe she was already using, or she had been using the marijuana for a period of time prior to her pre-employment
Yes.
period, right? So in most cases, the marijuana itself is a fat-soluble molecule. So after smoking, and it's inhaled, it's quickly distributed into the bloodstream, and the effects from that are immediate, 10, 15 minutes. And as Mike said, can last for a number of hours. And then it's distributed into the fatty tissues. The one that's most significant here would be the brain. Okay, and so the clearance of the marijuana after inhalation, 90% of it will be cleared from the bloodstream in about an hour. Okay, but the effects of impairment, once it has been deposited into the brain tissue, can last up to that 4-day period before it's completely eliminated from the system. So that level of impairment, again, is hard to determine because we have no way of getting a level from the blood that's, would be valid, or determining what that impairment is in the brain during that same time period. But the 4 days is a common time frame after smoking.
And this gives some great examples. It's worse with chronic users than it is with
Yes, it
periodic
is.
users. But chronic marijuana users, are, even when they're not intoxicated, perform significantly worse on neuropsychological tests of cognitive function, including attention, learning, memory, motor skills, and verbal abilities, impulsive decision-making, risky behaviors, impaired driving. Even by non-addicted individuals, their accident rates in car crashes are 2x over the rest of us. Single-dose administration in a laboratory setting significantly increased lane weaving. There's a great line in here. Impaired subjects' ability to visually track other cars, reduced reaction times, and interfered with their ability to divide their attention, and this is the part I like, e.g. drive and change the radio at the same time. And that's not a pretty high-order task, folks, right? This is not, you're not operating a crane there. You're just changing the radio station while you're driving, and you're having a hard time with that. 4 days? This is serious. So, something to be paid attention to and weighed as you're doing that dialogue.
So I need to chime in on this for a second, though, before we get to go. So I've two concerns that I have in my mind from just what we were talking about. One, I think it depends on there's many different types of strains and types of marijuana. So I think that the 4-day thing that we're hearing about, I think, you know better than me, doctor, on this, maybe you can help us, but I think that's a little bit overly simplistic. I think it depends on the type, I think it depends on the strain. Some types of marijuana, there's no high at all, some there is. It can be smoked, it can be vaped, it can be eaten in a brownie or something, so there's a lot of different types. So that's one concern I have. The second concern I have goes to the article that Mike was just reading from, and this is something that I said to the court as well. It seems that we are singling out marijuana for some reason. I don't know why. Maybe it's because it's the Federal One issue, which is sort of confusing things or making things, in my opinion, sort of a bit of a mess. But let's not forget, guys, you have people probably working for your companies, may even be some people in this room, and I pass no judgment at all because it's legal. You have people on painkillers, you have people on sleeping medications, you have people who are drinking a couple glasses of wine or a couple beers at home. So why are we focusing only on marijuana? What about the people that are working for you that have a couple beers at dinner? Maybe they're taking a sleeping pill at 11 or 12 because they're having trouble sleeping. And maybe they're getting up in the morning after a restless night of sleep and they're going to work. And they're going up on the crane. Do you know, are they impaired? Did you ask them how many hours they slept? Did you ask them if they took a sleeping pill? No. We don't ask these questions. Did you ask them how many drinks they had the night before? No. People just live their lives and go about their business, and nobody's really worse for the wear, for the most part, right? So I have my own bias when it comes to these things, and that's why, the beauty of having this type of discussion. But I just, felt the need to make those points.
I'd like to mention something that I'm curious about, if you don't mind. To the doctor's point, you have no baseline to start with for the 4-day period, correct? Because you have to get someone that has no THC in their system. By the time kids are smoking, the variable is all over the place depending upon the strain, as you said. For instance, I think, to your point, Adam, it's because pot has been illegal for so long, and now it's just thrust upon us. And now it's on par with alcohol and everything else. Should a CDL license holder, a crane operator license holder, have an accident, you bet they're blood testing him, and they'll find out how many beers he had, how much is in his bloodstream, and he's responsible for that. So there is a bit of culpability here. It's a sliding scale, but they go back and they find out. I thought it was interesting in page 6 of your health report, some cognitive skills can last, you could be at a loss 39 years later, it said. Now, I grew up in the 70s. I smoked my share of weed in the 70s. I'm 59 years old. Sometimes I can't remember something quickly. I think, crap, was it all that pot I smoked in the 70s?
That's old age.
Well, so the studies do show that individuals who begin using marijuana in their teens and use it chronically from there on will lose IQ points.
Well, I see it all the time.
Up to 8 IQ points. Yeah, and so that can easily affect all of those other parameters that you discussed. Speaking to Matt's point, there are different strains. If you go online and look them up, there are, I don't know, I think last I read was 799 different strains, right? Divided into whether it's the sativa strain, which tends to contain more of the THC, or the indica strain, which contains more of the cannabidiol. So if you're one of those patients who is using the sativa strain, that tends to be the strain that's more invigorating, used for the appetite, provides more energy. The potency of those strains do vary, even with the highest regulation among the dispensaries. There's no significant strain that has consistency with regards to potency. They all vary, and that's why they have names like Gorilla Glue and the one you had mentioned.
Sour diesel.
So the potency of them are so different and not consistent. So the potency you got this month may be different from the potency you get next month. And so I think that needs to be taken into consideration, as well as some of the other stuff that Matt pointed out with regard to the doctor-patient relationship, I think it's important, and Mike also mentioned it, that if you have employees that have been given a certification, because it is not prescribed, because, again, it's still Schedule I, illegal under federal law, and I think you need to examine that doctor-patient relationship. As Mike pointed out, is it a true doctor-patient relationship? Has the doctor discussed with the patient the pros and cons, side effects of using medical marijuana? Have alternatives like Marinol, which is an FDA-approved synthetic marijuana, has that been tried? Have other alternatives, like, we speak to glaucoma, have eye drops been used or attempted first before going to using medical marijuana? Those things need to be examined, as well as the physician who provided the certification. Have they been to continuing education courses? Some states require them to before they can go ahead and prescribe. Some states require physical exam. Was any of that involved? So there are a lot of other parts of getting that certification that go into it before that card is given. And I think as employers, all of that also needs to be examined when you're going to have this discussion with this employee, to kind of examine what else has been done prior to.
Can an employer ask that, though? I mean, you're kind of delving into their personal life.
And I think that's kind of what Matt pointed to with regards to the invasion of privacy.
I see no problem with having that dialogue.
Yeah, but you're the Atlanta Falcons, man.
No,
Yeah.
but listen, under Chapter 151,
That's the
because this
best.
case was decided on a disability discrimination theory. That is called the informal interactive dialogue. Interactive dialogue. If the worker says, you can't talk to my doctor, I'm going to hang that around their neck and hold it against them, okay? If they say, I'm not going to allow you to speak to my doctor, you say, that's fine, that's your right, I'm not going to allow you to work here. You have to discuss with me the safety implications of your marijuana use. Now, are you going to get away with that with a Christina Barbuto demonstrating deli products in the market? Probably not. But are you going to get away with it with somebody who's in a safety-sensitive job? If they refuse to allow you to talk to their doctor, I think that would be a very tenuous spot for an employee to be in. And a couple other issues that you raised that, if I can back up, because they're important. You said CDL holder, a commercial driver's license holder. The Barbuto decision does nothing, and could have done nothing, with respect to DOT rules, okay? So a DOT-regulated driver, an NRC-regulated nuclear worker, an FAA-regulated pilot, go through the alphabet soup. Those folks are not, this does not change the rules, okay? So the DOT will continue to test for pot and continue to disqualify you for a CDL holder, to hold a CDL. That didn't change, the decision is specific on that. Are any of you doing work are you federal contractors? Anybody covered by the Drug-Free Workplace Act?
Occasionally.
This is an untested
We also
theory,
do
okay?
gas pipeline distribution as well, so
Yeah.
we're regulated by DOT there.
Okay, but the Drug-Free Workplace Act affects federal contractors, so like defense contractors and the like. This is an untested theory, okay? But the DFWA mandates a drug-free workplace. It does not mandate drug testing, strangely. I have advised clients that though it is untested, and I'm not sure I will win, if you're a federal contractor covered by the DFWA, you could rely on that to refuse to accommodate marijuana use. I could win, I could lose on that. That's untested too. Another point you raised, though, about impairment. There is now no test really to know if somebody's impaired. You're going to get 61 nanograms per milliliter of urine. Does that tell you, what is it, Wednesday? Does that tell you that somebody smoked a lot of pot Sunday night or a little bit of pot 2 hours ago? The test doesn't really tell you. The test is incredibly precise. I mean, a nanogram is very small. To find nanograms per milliliter is a remarkable thing, but it doesn't tell you impairment. As management side lawyers have a black little cynical heart. In that capacity, an employer who thinks someone is impaired and can document that with objective facts. You smelled like pot, and 2 people attest to that. Your eyes were red. You were slurring your words. You appear to be unsteady on your feet. And we sent you for a test and you had 61 nanograms per milliliter. Person may come back and say, I wasn't impaired. I smoked pot on Sunday. I was fine. I think the test, in conjunction with the 1, better yet 2, better yet documented supervisors who attest to that you seemed impaired, I think that's pretty bomb-proof. I could lose that case too on a bad day, but I think you're going to win that case most times. So even if the Christina Barbudas of the world, who you may say, I have to accommodate her, the case does not say she's allowed to be intoxicated at work. And if she's showing signs of intoxication and you have a positive drug screen, I think she's out of luck then.
Yeah, and even as an employee side, normally an employee side, I would agree with certainly that last statement. There was no evidence that Christina was impaired.
Oh, agreed. I didn't mean to.
Yeah, no, I mean, but there wasn't. It just wasn't there. She wasn't impaired. And there was really no evidence or allegation of that, nor did we argue to the court anything about impairment. I would not take the position that an employer has to keep somebody employed on the job, at least for that day, who's impaired. Never said that, never would say that. What I would say is, again, and I may say this a couple more times today, I don't think that's a marijuana-specific issue. If someone smells of alcohol, they shouldn't be on the job. If someone's falling asleep at their desk because they took 2 sleeping pills instead of 1, you should send them home, right? So, no, they should not be impaired. I don't care what they're taking. And, employers have to make those judgment calls, but I think they make them every day anyway. Someone's unsteady on their feet and they smell the booze, that's a problem.
But for example, we can take that same person who's falling asleep at their chair, send them for a drug test, and the test is going to come back to us as a negative because they have a prescription for that medication, and we're not going to be informed of that.
So, this is a failure of an MRO, what you just described, and it's all too common. I don't really understand some of the approaches that MROs take, I'll be polite. If you have safety-sensitive positions, I think you need to get out ahead of this and talk to your MROs and say, we have lots of safety-sensitive job here. And even Ritalin, Adderall, amphetamines, or Percocet, OxyContin for pain, or sleeping pills, or even potentially some anti-anxiety medications, legitimately prescribed, FDA-regulated, could implicate safety. I think you have to tell your MRO, we have safety-sensitive jobs here, and if someone has a legitimate script and tested positive for something that could implicate safety, say something to us like, pass with safety concerns. I like that phraseology. Which tells you they have a legitimate script for the oxy, right? And you come back and you say, okay, Jane Doe just passed with safety concerns. What's Jane do, right? She's in customer service. That's a pass. She's a crane op. That's a conversation, right? But if your MRO just says pass and leaves you totally ignorant of that, that's a failure of the MRO.
But they
And
told
it's all
us
too
that
common.
they're legally precluded from telling us that.
That's bullshit. That's my legal.
That is a legal term.
I do this all the time. This is the easiest job in medicine, being an MRO. You just cash the checks, I think. It's unbelievable in the stories that I hear, that kind of thing, all the time. That's unacceptable. They're taking a safety risk with your people, your equipment, your liability. Lives depend on this. That's unacceptable. And if they keep saying that, get a new MRO.
Okay, well, that's good to know that they're not legally precluded.
No, that's ridiculous.
So should she push back on them for that?
Yes.
Yeah.
Well,
Yeah.
I guess I'm not even familiar with the acronym MRO.
Medical review officer. A medical review officer is the person in between the lab and you.
Okay.
So the lab reports out 61 nanograms per milliliter of opiates. Now that could be heroin, that could be legitimate Percocet. The MRO then calls the donor and says, you tested positive for opiates, is there a legitimate reason? Yeah, I take Percocet for my cancer pain. Okay, send me your script. They compare 100 milligrams 3 times a day, that's pretty consistent with 61 nanograms. Pass, like her MRO, or pass with safety concerns like a good MRO. But they're independent from you. They typically work with drug labs, First Advantage, Quests, they all have MROs.
And they don't have HIPAA concerns with releasing that level of detail, just the safety concerns or no safety concerns?
Certain lawyers will say drug tests aren't even covered by HIPAA. I'm not quite that aggressive, although several of my competitors will have given that advice. I've seen it. Once drug testing results are in your files, they're absolutely not covered by HIPAA. And a lot of times the MROs and others are getting HIPAA releases. I mean, you need to have these communications.
So back to the question asked earlier by this gentleman, what is the interactive discussion with the doctor? I mean, I know I've had it hundreds of times with an employee, but having that conversation with their physician, you typically need a release to have that. I mean, because that's a problem with ADA, is there's no official paperwork, like we're used to seeing with FMLA, where there's a lot of sample paperwork that you would submit, and you get it significantly more detail because it's solicited in the certification of healthcare provider. But when it comes to ADA and that reasonable accommodation, the interactive process, it's very vague. And so what would be the reasonable conversation that you can pick up the phone and say, I have a note that's real vague that says you have light duty or limited or whatever it is. How much can you, like you said, if you can get them on the phone, I'm guessing you're going to get very little information.
If they ask
If
for
I
a
called
HIPAA
you, would you give
release,
me information? I mean,
if they ask for a HIPAA release, which would be reasonable for them to do, you know, you say, send me a copy of release, I'll ask the employee to sign it. And if the employee refuses to facilitate the dialogue, again, that's on them. And you can take action. Well, you haven't been able to establish what is or is not the safety implications because you refuse to sign a HIPAA release. But I would expect many doctors, if not all of them, to ask for that release, and that's okay. I often say, give me your release, because if I give them the one I like, they don't like that one, and burn another 2 weeks trying to get the right release in there. But you get that, then you have the dialogue, and Matt is correct in that you've probably had this dialogue with other drugs, right? You've had it with respect to opiate-based painkillers or sleeping pills or amphetamines for ADHD. I think the Supreme Judicial Court, the Barbuto case, just said, oh, well, if they were thinking about it this way, this is nothing new for an employer. This should be standard. And if marijuana were prescribed by people other than doctors that like cannabis care, I would probably agree. But I predict you're going to have a hard time getting the answers you need. Maybe I'm too skeptical on that.
what were you thinking? You could see your.
Oh, no, I mean, I think it was answered. I mean, I think that I would advise my employee clients to sign that release, right? Because I think it then comes back with an attorney like Mike, and then it looks bad on my client, well, why weren't,
Cooperating.
you, exactly. So I would have no problem with that. I think your underlying question though, how deep can your conversation be? I don't know that we know the answer to that.
Nor would I
I mean-
know how to interpret the answer.
Well, then, and I think
You know what I
Mike's
mean?
right that the SJC decision raises some questions. I mean, it says what it says, but I think there's a limit. I mean, and I certainly I would want my employees, clients to cooperate and to provide information. But at some point, and I don't know where the line is, but at some point, the employer can go too far in their discussions with the employee. If it really gets into, well, you really shouldn't be taking that. The employer's not a doctor, right? Who are they to say what somebody should or should not be taking? So, I mean, I think having the conversation, I think exploring it, but I don't know where that line is,
Generally speaking, you'll probably want to inquire more about limitations and safety than about the underlying stuff. I mean, I don't know Ms. Barbuto's condition other than to know it's Crohn's disease, but so I'll use her as an example. This may not be fair. It really has no bearing whether Ms. Barbuto has diarrhea or vomiting, okay, or both. I don't care. What I care is her limitations and how it impacted work and whether the marijuana creates a safety problem, right? The Supreme Judicial Court sort of pointed us towards medicine and away from limitations in a way that I find very frustrating. But if you're having this dialogue outside of the marijuana context, in the ADA world, it doesn't really matter if the person's taking opiates for back pain or cancer pain, and you're probably better off not knowing. What you want to know is what kind of limitations are impacted by your pain. How much can you lift? Do you have to come in late because you weren't able to sleep? Right? I don't care if that's because of cancer or anxiety, but it's the schedule adjustment and the limitations that really matter. So I feel like I'm pretty, even though marijuana's new and this SJC decision throws us some curveballs, those conversations you've had for a long time, and I would rely on the things that you know and know how to do and do well. That's probably a safer way to go about it.
But it seems like the uncertainties about limitations with marijuana are a lot greater than they would be with other types of prescriptions. And I don't know how you'd ever have a level of comfort under that sort of situation. I probably
Can you be more, what do you mean exactly?
Well, just because of the type you use and the mechanism you ingest
Got
it and the strength of it and how it affects you personally, given your history. How would you ever feel comfortable, in a situation that no matter what they're using, that it's going to not impair them? So then I would start using the deliberative process as a way to prove that they can't do it instead of the other way around.
Yeah, no, one of you guys
Because
can.
I'd be looking at a situation where that person gets in an accident in our employment and now we get sued. And I have to be able to say, okay, so I'd be trying to find ways to eliminate them, not to allow them, basically.
Yeah.
Which is not the intent. but
I'd
that's-
love what you think though from an age, there's a lot of this, it's right in your wheelhouse. How does this land with you and where are you going with this
Well,
in the
this is
future?
just so new to me. We have a very vague drug policy at our company, and I don't know. I don't know how to answer the question because I really don't know a lot about how to go about talking to people about their addictions and the reason why they're on marijuana and stuff.
Glad you mentioned drug policy though, because I think that's a key takeaway for everybody here, right? Which is that your policy should be updated. And now with Massachusetts, we now have 12 states that require some form of accommodation, some job protections from medical marijuana. That leaves 26 that don't. Now, I think Matt's position is probably the winning one going forward. I would expect more states to follow this lead, but several states have already weighed in on the other side. You have to decide, before you write a policy, you have to decide philosophically, are we going to provide more rights to somebody in New Mexico or Colorado than they're entitled to have a one-size-fits-all if you're multi-state? But you should have a policy that at least does not say marijuana is illegal under federal law and you're out of here. That'll get you in a world of trouble in Massachusetts, Rhode Island, Connecticut, Maine. Decide, set a policy, train your people, follow. We're blogging, I'm sure you're blogging. We're blogging on any new development. Find a good, reliable place to stay up to date on this so that you don't get sandbagged. Matt said the HR person in Advantage Sales and Marketing, or had you put it, was sort of junior. She certainly was, okay? I'm not talking out of school when I say that the general counsel of Advantage Sales and Marketing wished that somebody had bubbled this to his desk before he found himself, $100-something thousand in the hole and losing at the SJC. And went back to the trial court, right? He's like, good God, she was demonstrating deli products, right? How did I end up here? So make sure you don't fall prey to that by having your people stay abreast of these changes. The confusion's understandable, right? It is illegal under federal law. It remains illegal under federal law. The current Attorney General, for as long as he holds the job, hates marijuana. The last one was open door to it. My God, if that isn't confusing, what is? Right? So, within 2 or 3 days of any development, we're blogging on it. Most firms are. But find one that you like, that you can rely on, so that you don't find yourself sandbagged.
I think it's also important, just to include in those policies that medical marijuana use is not allowed to be used while on duty. And make sure that's clear in your policy.
Right, that is true. The SJC decision does not say anything about on-site use, nor obviously, as we talked about before, about impairment. So we're talking about off-site use and not impaired.
But how do you balance that with somebody who's certified to treat their incident? They say, oh, I'm having a reaction right now, I gotta go treat myself.
With marijuana or with something else?
With marijuana. You know, I mean, that's their treatment, right?
Migraine costs a pill.
No, I would say probably no to that.
I would certainly say no.
Yeah, I mean, there's that, from a humane perspective, you might say, okay, to take this one particular occasion and we'll give you a mulligan or something, but from a legal perspective, I don't think you have to accommodate on-site use.
Hey, let me ask you a question. Do you have the right to possess pot at work if you have a card? I won't hold you to this, I'm just curious.
I think it depends on your drug
I
policy.
don't think you can,
What's the definition of hold?
I think it's a no possession. And most of the policies will say, not be in possession of.
I know, but I started to have this parent, because that's been my
But-
advice for a long time, and then I went back and read this again, and I think the SJC would, because they just want to treat marijuana like Advil. SJC would say, you can carry your meds as long as you don't take it at work. What do you think? You gonna sue me if we fire somebody who has a bag of weed in their pocket?
Well, but, I mean, I guess two answers. Why would you care if they had it or not, if they're not using it? Number one. And number two, I mean, I don't know that they're saying it's like Advil, but I do think we get into this very interesting federal state issue, which I don't know that we need to spend a ton of time on today, but as we argued before the court, you know, I understand some confusion about it, but in Massachusetts, the legislature, we have said in Massachusetts that this is legal. And if you are doing business in Massachusetts and you're working in Massachusetts, you cannot just fall back on federal law and say, well, federal law, so that just doesn't work that way. And we can give other analogies, you know, in other contexts where it's just not the way it works. Certain states can regulate the way they want to do it, and Massachusetts may do it differently than Wyoming, and that's, you know, that's okay. There are laws that, what we call preemptive field, where federal law does trump state law. The drug laws are not typically that way.
I think employers are going to care very much if you have a bag of pot in your pocket. I know my clients would be absolutely apoplectic at somebody who was caught with a bag of weed in their pocket. And I am going to tell them, I think you're on safe ground terminating them, but I can't guarantee it.
But if you put that in your
Drug policy.
Highly be aware of employees who are maybe using edibles or vaping, in which case it may not be obvious to you that they were consuming marijuana at work.
In the case of this Barbudo, she's demonstrating products. So she's not working for the supermarket chain itself, but she's working for the purveyor. How does she get there? Company-owned vehicle, or is she driving on work time in her own vehicle?
She's driving. She's
Would
just
that
commuting.
not be a safety concern at that stage?
She didn't have a company vehicle. She's only on the payroll when she clocks into the market.
Massachusetts doesn't have a per se
And then also
limit.
too.
No, I know what you're saying, sir. So it's a good question. So I think if you want to talk about Christina herself, I don't think she's on the clock when she's driving from her house to work.
That type of
But there are other jobs where there are, right? I mean, I have a client.
sales, business development, you're in the saddle, you're working.
That's right. That's right. I have a client who, the other day this came up, he was going to pick up troubled youth, and he was going to pick up a kid to bring him somewhere, and he got into a car crash. So from a workers' comp perspective, you know, he was working.
It's compensable.
Don't you own an employee a certain amount of time prior to his start, in conclusion? Say 7 to 3:30. Are you somewhat responsible for him, say for 30 minutes prior to or after? I just want to make sure from legal.
I would say no. I think that's pretty clear.
If that 7 o'clock employee who clocks in and at 8:30 drives from your site to the next site, you may own them in that spot, but at 6:30 AM, you don't own them.
But let me ask you this, if I may, just one more. and I
Then we get-
Go ahead, you first.
No, you and then Bill.
Okay. Totally selfish, I work for a utility. All my employees are CDL. That's the common factor. So while this is fascinating to me, we still can maintain a zero policy. But we do in an effort of mercy, because I've had guys fail. We suspend them for a period of time, we get them help, we bring them back, we sit down with labor relations, we explain where they are. One more time, you're out the door. They have their union representation right there. They agree to that. So they fail again, it's bye-bye. There's no legal, there's nothing else. So CDL trumps our conversation here.
I think so. You were talking about that
Yes.
before, right?
Totally
Yeah.
regulated.
Yeah.
Yes, it
I think
is.
that's right.
That's crystal clear.
Do you,
Okay.
Yeah.
we talked earlier, very, very briefly, you know, when someone says, I think somebody is using, should we be adopting the same kind of reasonable suspicion policies that we have to alcohol, where unless you are actually trained as a supervisor, probably the recommendation is, not we're sending you for a drug test, I want to send you for just a fit for duty medical exam. And then at that point, if the physician or the medical professional identifies something that's a condition that warrants an MRO, now it's between the individual, the physician, and the MRO, because they've just been sent for fit for duty. You know, hey, Rick has been stumbling around, is he, you know, working 2 jobs, is he moonlighting, is he really overtired, or is he using something from the point of view of a foreman or a supervisor or some sort of leader for the company? They tend not to be more exposed. If I'm going to send you for a fit for duty, just get you checked out, make sure you're okay, if you're a little tired, some time off your feet, whatever. And then the physician discovers, you know, hey, there's some indicators here, maybe we should do a urine test or a drug screen, and then something is triggered. Now that's all off board and being settled with the MRO, and the supervisor is not exposed to the issue of, you know, being a deponent and saying, well, you know, what is your background and your training, and being able to assess and evaluate somebody.
3 thoughts.
We really have to
One
kind of
is,
think that through.
I totally support training to help supervisors spot intoxication. It's a great idea. Supervisors are not comfortable, especially in drugs that don't have a smell that we're used to. Like, we know what drunk smells like, we know what weed smells like, but, you know, do you know what opiate intoxication looks like? And everybody's drug checklist will say, pinpoint pupils or dilated pupils. And I'm gonna say, which the hell is it? Are they small or are they big? Get the training. But a lot of employers don't. Okay. A supervisor who comes forward and says, I'm concerned that this person is intoxicated, and if they document that on a sheet, I think you can send them for a test. You may choose to send them to a doctor first, but the law doesn't say you have to. And if they go to a test and they fail, it's a self-validating loop. I thought you were high and you came back, you popped positive. Guess what? I was right. I think that's bomb-proof, honestly. The last thing I'll say is I had an expert witness on the stand in a case, and he said 15 minutes and access to water is enough to defraud a urine test. Okay? So you send this guy, you say, drive to the doctor for fitness for duty. If he has a chance to go to the bathroom, put his head under the faucet, it's over, game's over. He's diluted his urine such that he's going to pass the test, even if he's high. And of course, you have to use urine or oral fluid for a reasonable suspicion, because the hair is still under the scalp.
Right.
So, you know, I think you get that person, if they look intoxicated, you get them to the lab in a supervised way. Somebody drives them.
Somebody
If they're
drives
intoxicated,
them.
they're not driving themselves anyways.
Right.
Right.
And you send somebody who doesn't let them pull over to a store 24 and buy a quart of water. And if they come back clean, no harm, no foul. You pay them for the time. There's no adverse action to get sued on. But I don't mess around when it comes to this stuff. I get in the lab. Be in the cup, man.
Just for the records, I grew up in the 60s and I didn't smoke marijuana. I'm probably one of the only ones that didn't, because at 11 o'clock when they all went to McDonald's to get cheeseburgers, I drove all their girlfriends home. But my question is well, probably all these, I guess, but we do drug tests, pre-drug tests. You know, the urine, and I do them myself, check it and everything else. And it's the 5-pan.
Yep.
How long is that, if he smoked marijuana, would that be in his system? I know you mentioned an hour and whatnot, and before you answer, I got a little more. I have the New England region for crane operators, so if there's an accident, they want us to test right away. I test, I let them go pee in a cup. I don't watch them, which is, I don't know how legal that is also. And again, I could have a job in the middle of Connecticut. It takes me 2.5 hours to get there because there was an accident I was called on. What's my time frame if I'm, if this, like you said, this guy starts drinking water and everything else and everything, I get down there, am I wasting my time drug testing him or?
All right, so, a number of questions. We'll start with the time frames. So for chronic users, before a pre-employment test.
Yeah.
So they tend to be obviously positive for a month or so until they abstain and can clear from their systems. For somebody who's just an occasional user, maybe on the weekend, because it's a lipid-soluble molecule and moves quickly from the blood into the fatty tissues. If you get them, believe it or not, in maybe 12 hours after they smoke, they could be negative because now all of that THC has moved into the fat tissue and will not move back into the bloodstream until there is none left in the bloodstream, and then comes back out into the bloodstream and released to maintain like an equilibrium. Okay, so if you catch somebody in that 12-hour window who's not a frequent user, they could be negative. And again, there's no real, I don't want to say like, that it would definitely happen, and I know people who would taken a test would probably not take that risk, but the possibility exists.
Quarterly, we're the second largest crane company in America. So quarterly, I get people from New England area that need to be drug tested. They'll send
Right.
out the
Random.
randoms, exactly.
Yep.
And there's no time frame in there. So if I have Joe Schmidt, who's in Boston, I'm saying, hey, your name came up.
Right.
You're not going right now, but you've got a week or whatever. And Joe Schmidt says, well, I'll lay off the stuff and then I'll be clean by that one,
Well, so randoms are usually, you announce your randoms?
Yes. Well, we'll tell the person. When
So you
Well,
announce.
they give them to me.
How far in advance?
Yeah.
They can
So
be a
ran-
month.
We're told
Right.
5 minutes before we have to go.
Right.
Yeah.
That's not a random at that point.
Yeah.
No.
More of us
So
are-
See,
random
the
is
problem
more
with us being
unannounced.
is I get a random, again, for Joe Smith at Gemma Power Plant in Connecticut. I gotta get down there, let him know, and he's got time, it's.
Right, so, I mean, I think at that point, he should not be allowed to consume any water. I mean, he would really need to drink a lot of water in order to get a good dilution to make the cup test negative. But I'm sure you're doing split samples,
Yeah.
right? So most likely would be picked up on the GCMS, not a problem.
We send them to a clinic.
Oh, right, so they go to the lab and then your lab does the split
Right,
analysis,
exactly.
right, so,
What do you do with a negative dilute?
Let me
That
just
sounds
address
like
this
that, right?
first.
We send them,
I just want to throw one point. If you're giving them more than enough time to abstain and pass, and to drink water and pass, so I would.
Yeah.
Yeah, we
I would
don't
tighten
really,
up.
yeah,
I would
announce
also
random.
consider.
It seems
given-
kind of lax.
Given the challenges you've got with people all over.
Yeah.
You could go to hair. Now, hair doesn't work post-accident, hair doesn't work reasonable suspicion, because that hair is still below the scalp. Hair is great for pre-employment and random, right? It's also less invasive of privacy. We all get haircuts in public places. We don't, pee in public generally. So it kills two birds with one stone here for your situation. You can't dilute your hair. Now, you can shave your head, and you can, some of this stuff gets a little ridiculous.
You can have.
Yeah, there's always some way to do
There's always somebody trying to
There's
teach us
always
this.
somebody trying something, and
Yeah.
I could tell you stories, but you might want to go to hair. Hair looks back as long as the hair is around. They found evidence of cocaine in Incan mummies' hair, 3,000-year-old hair. As the Inca chew coca leaves, that's like a cultural thing, and it gets in the hair, and once it's in the hair, it stays in the hair, and you can find it in a 3,000-year-old strand of hair. Interesting. Okay. So you might want to go to hair.
Yeah.
To negative dilute, the urine has to be so dilute to be deemed an invalid sample, in my experience, to be almost ridiculous. And they measure dilution on creatinine. Did I pronounce that right?
Right, that's right.
The creatinine factor.
It's
And all of us,
specific
when you go in for a physical and you give urine for your physical, they test your creatinine. Why? Test how your kidney function. Okay. So they look at the creatinine factor, and if it's sufficiently low or high, whatever it is, it could be invalid dilute. But they set that level. I mean, it'd have to be like this to fail. So if someone does come back dilute, they were really defrauding that test. I mean, lots of water. It doesn't often happen.
Not just negative dilute, but invalid dilute. I've not
And
seen
negative
that.
dilute is such a conundrum. Okay, all right, so now we retest you. Great, we just gave you another week to clean up. You might want to retest that person on hair. I like to catch people. I mean, I think some protocols are set not to catch people. I might argue yours is set not to catch people. You want to catch people, you can't give them any warning. You use hair when you can.
Hair covers a period of about 90 days for most drugs.
Well, where do I get, we use Concentra. Have you heard of that?
Yes.
drug?
Yep.
Would they do hair?
I'm sure they do hair,
Okay.
yes.
I didn't know.
And as far as observed collections, I think in most cases of observed collections are done when the collection site person, if you've taped the faucet, blew the water, had them, empty their pockets
Yeah, right.
beforehand. I think most observed collections are done when the collection site person feels like, they are, doing something inside the restroom, using additives, masking agents, or what have you.
Tipping.
Yeah,
That
we've had
type
it.
of situation,
They brought it
or
in.
it's a return to duty scenario, and your policy specifies that they would be observed collections.
They sell the Wizinator in 7 different skin
Right.
tones. Ponder that for a second.
Right, so it's observed collections, usually those are the only circumstances in which you would do those.
That sounds like something that'd show up on Shark Tank.
Oh, there's big money in this stuff. My
Yes, there
favorite is this tea that you brew and it beats a drug test, okay? And they sell you this tea bag for $40, and it says, brew this tea in a gallon of water and drink it all. And you're like, dumbass, it's not the tea, it's the water. But I just sold you a tea bag for $40. I can clearly have online work. Okay.
Why couldn't I invest in that company? Wow.
I have a question. This is very frightening to me to think that the chance that a person could be impaired for a really extended period of time, maybe 4 days. How long is a person impaired, part one of my question, drinking alcohol, for instance? Let's say I went out tonight and drank a 6-pack of alcohol. How impaired am I going to be 12 hours later when I go to work and jump in a crane and I smoke 3 joints tonight? How impaired am I going to be in 12 hours when I go to work?
Wouldn't that be the person itself?
Right, so that's on an individual basis, because
Yeah.
you have to take into account other considerations, just not like the potency of the marijuana, but also liver enzymes. So some people have fast liver enzymes, some people have slower liver enzymes. how quickly are they metabolizing the marijuana? And then you also have to take into consideration body fat content, because those people that have higher fat content will retain it for a longer period of time than somebody who's leaner. So trying to determine a level of impairment takes into account a whole host of other factors that aren't really comparable, in fact, to alcohol, because we know that, impairment, as we define it, at 0.08 is what's been determined. With marijuana, it's considered to be a what they call counterclockwise hysteresis, which means that the impairment doesn't really occur right after you have smoked marijuana, much like it would if you were drinking alcohol. So the impairment and the effect comes much later, hours later, than the initial smoking. It's so hard to determine impairment, again, because not only do you have all of these other factors that come into play, but then that release from the system, and mainly, the fat deposits back into the bloodstream, release from the brain, more or less, because the brain is about 60% fat. So how quickly is that being released? And how quickly are you returning back to baseline?
And we have an impairment test for alcohol, right? 0.08
Right.
if you're pulled over.
Yes.
DOT has a different rate, 0.02 to 0.04, I think.
There's 0.03 in Massachusetts.
104.
104.
The DOT has very granular regulations about this that are far lower than 0.08. But marijuana, there isn't one. I believe, you may know this one, I believe that Colorado has an OUI standard for pot.
Yeah.
But,
I'm not 100%.
5
nanograms?
5 nanograms per ml in Colorado. But I think it's in addition to having observable signs and symptoms.
So that's what I was saying earlier, which is somebody who had red eyes, smells like weed, send them to the lab, they come back positive. I think that's a defensible termination. Because the Barbuto case doesn't say you can be intoxicated at work. In fact, she specifically alleged that she was not, and they relied on that. Okay.
Back to your case for a minute, Adam and Mike. The Barbuto case, if it goes to mediation and you guys settle, you're all good, everyone's happy, we still have no precedent. Is that correct?
Well, you have this. You have the Barbuto decision from the SJC.
Will that be precedent setting so that you will be able to cite that because it's not a judicial, it's
No, this is
mediation.
judicial.
So
The mediation is private, but the decision that the Supreme Judicial Court came out is precedent.
They stand independently of each other. So what?
But if you mediate and you agree, that is the standard. Judicial recognizes you worked it out privately and this is what we
No, I think you're mixing apples and oranges a little bit. So,
Probably.
yeah, no, that's okay. I mean, it's if you want a lawyer, so the SJC decides all kinds of cases, right? The SJC has decided this case. So the SJC has said, read the decision later. It says what it says, right? Talks about the interactive dialogue. Talks about the fact that you're not just out if you come up positive, if you're using it medicinally. It's more complicated than that. It's more nuanced than that. I don't know that the SJC cares what happens to the Barbuto case. We can settle it. We could go to trial. I could win. Mike could win. The SJC decision stands for the rest of time, unless and until the SJC comes out with a different decision, right? 10 years from now, 20 years from now, 50 years from now, it could overrule this decision with a different case. And the SJC can do that. It's just like the Supreme Court of the United States could do that, right? With whatever, abortion or whatever, right? So don't worry. No one has to worry about what happens with the Barbuto case, I would say, going forward. you can take from this case stands for what it stands for. I don't know if I really
No,
answered
no,
that.
I get it, rather
Clearly.
than kick it back.
Yeah, I mean, look, if I
There's
would
one
have
takeaway though, which is that, like, for instance, the California Supreme Court came out and said that in a case called Ross versus Raging Wire, that a California employee had no job rights with medical marijuana in Massachusetts. That case was not decided on a disability discrimination theory. The California Supreme Court could revisit that and could go the Barbudo direction, right? If I had to bet, I would bet that California is probably likely to do that one day. So there's going to be continuous developments. Maybe we'll even have developments in Barbudo. I mean, one day when I was a little agitated, and Matt and I were talking about this case, I said, well, congratulations, you won the war, right, Barbudo. I'm going to win the battle. I'm going to get Ms. Barbudo a 0, right? I'm going to ultimately win. We're going back to trial, and I will win. You established some great new law that you'll use, but I think I can win the Barbudo case, her own case. You know, and maybe I'm right, maybe I'm wrong, who the hell knows?
You're wrong.
But you may, but we may get more decisions out of the Barbudo case, and then there's going to be Smith versus Jones next year. So unfortunately, you'll have to follow all these developments, and it's going to take a long time to answer all these conundrums that we've kicked around here. We'll get one here and one there, we'll get a little clarity, maybe the Supreme Court of Arkansas will come out with something that's analogous that we'll rely on, you know. It's going to be a challenge, and our clients, I'm sure, I speak for both of us, are struggling. They're looking for advice. They're trying to do the right thing, but there's a lot of unanswered questions. I mean, how many times have I said in here, I think you could win that, maybe, right? Maybe that's cold comfort to you. You know, you don't want to be the test case, but you got to protect safety. You're in a tough spot. You know, find somebody you can trust to get advice from. Stay abreast of the changes. I would encourage you to put safety, you got to put safety first. When we say that, it's easy to say, right? But if you're balancing, God, do I keep this person on, or do I invest in safety? I mean, if somebody has a crane accident, I mean, people die. You know, the Barbudo case, Ms. Barbudo wasn't teeing up safety issues, right? So that employer might well have taken a different approach. I think if they knew what was going to happen, they probably would have. But you guys in bridge building and crane operations and CDL holders, my goodness, it's a different animal.
So, a couple of things about that, and you hit on it. The decision that I think was reached is that employers can't flat out say, you can't smoke pot and work here. That's kind of what I'm taking away from the decision. Now you can stack that up by saying, okay, safety sensitive people, that's what we do. We have a safety sensitive pool. They're the ones that get tested. But now you layer on top of that recreational marijuana is legal. And the bulk of a lot of the people that work for us are of a generation who are going to enjoy recreational marijuana, good. But they're some of our best workers. So now they're in safety sensitive, so we have to test them. And how do we deal with that? And we are signed with laborers. So I'm curious if there's any discussions or any, you know, what the laborers union is doing. Are they talking about it? Is there any proactive measures they're taking?
Well, I think as far as the laborers union goes, you know, this has been all resting on the Babu case. The case before that, which we thought would set the precedent, was Coates versus Dish, in which Mr. Coates was a quadriplegic who was in customer service and had a test done at work. He was using medicinal marijuana. He was terminated. He was working in Colorado, and Colorado upheld his termination based on the fact that his use of marijuana was an unlawful act. And his was off duty as well.
Can I just say one thing?
Yeah.
Come back to you. That was not a discrimination case.
No, it wasn't a discrimination
Neither was the
case.
California. And when we started, Mike said there have been a bunch of states that have gone against employees. A lot of those cases were not discrimination cases. Why those lawyers brought those claims, I can't really speak to that. So you're right, Coates is a well-known case, it's out of Colorado. Some people were surprised by it because it's Colorado, but you have to look at the medical marijuana law of that specific state.
Right.
Mike said some have anti-discrimination provisions, some don't, it's all true, but it's complicated to see what claims that plaintiff and that lawyer brought, because the court is only gonna decide the claims that are before it. If they didn't bring their strongest claim, that's unfortunate, because now they have a bad decision out there from my perspective. Anyway, I didn't mean to interrupt, but I just want to say it wasn't a discrimination case.
And I'll just finish by
Coates.
saying that, Matt's right, so it's all, new to us as well, and moving into it. And I would say the one other case was the Noxinger case in Connecticut, in which she was using FDA-approved, prescribed Marinol and was terminated, and that was a discrimination case. So it's hard to kind of reach a decision when you have these case-by-case decisions in these individual states with different state laws that have set, different precedents.
Different state laws, different claims.
Especially if you're an employer who has employees working in different states. So I can't really answer that question because we're kind of where you are now.
Well, let me weigh in, because I didn't give my intro. So I'm at Ogletree Deacons. We're a 52 office firm. We're worldwide, and all we do is labor employment. And I chair the firm's drug testing practice group. So I field that question 4 days a week. And I have had so many employers call and say things like, I can't staff the third shift if I screen for pot, right? And what the hell am I gonna do, right? Do I drop pot from my panel? Because I need to run a third shift. And you're in rural Maine, the third shift workers, you're not gonna get a full complement of people if you screen for pot. And it's not my job to tell them to run the business, just to give them the risk, right? So all I do in that response is say, unless you're DOT, FAA, NRC regulated, you don't have to drug test. I mean, nobody tells you have to drug test. Even the Drug-Free Workplace Act doesn't say you have to test.
Nope.
So legally, you don't have to test, okay? Unless you're a CDL holder. Safety-wise, with all the stuff that's in here, you may want to test, okay? You may not want to test any more than you absolutely have to. You may want to give people the opportunity to test, fail, clean up, and keep their job, right? One bite at the apple, which is required in Minnesota, strangely. Or you may not. But only you can balance all of that stuff, right? You've got privacy risks. Even if it's not unlawful to drug test people, it is offensive to some people to have to pee in a cup. And that should be thought about too, right? Your human resources people are going to say, do we need to do this? It's expensive, right? Hair drug testing is 40% more than urine, and urine is plenty expensive alone. So you've got all these things. You've got financial, legal, HR and employee relations, safety, right? You got to balance them all. I always say you got to put safety first, and marijuana does have real safety implications. But that doesn't mean that everybody has a legitimate opportunity to impact safety. Right? Only some. You got to communicate well, especially in a unionized context, by the way. I polled the labor lawyers in my firm, and I said, give me examples of when drug testing triggers union drive. If you want to remain, union-free. Do you want to impose a new random test to tick people off and have them fill out cards and bring the union in? Maybe you don't. And I think that comes from legitimate objections to the privacy. I've been working here 10 years, now I have to pee in a cup when you tell me to? What am I, a little kid? I get that. So now you may have to balance that too. You put all that in the mix and get all the stakeholders in the room, the safety folks, the HR folks, the legal folks, and come out with the best decision.
I would add one thing. So I think you mentioned recreational. I view it very differently than medicinal. I think Mike would agree. Companies can have, I don't say whatever policies they want, because that's obviously within the law. But if you're not discriminating, you can have a policy, I think, that says you're not gonna hire anyone who uses recreational. Now, you may have a problem filling all your slots, that's a different issue. But the Barbudo case and what we're talking about up here does not really have to do with recreational.
Maine is an exception, by the way.
Maine?
Maine provides protections for recreational weed, if you can believe that.
Only Maine?
Only Maine.
Okay,
Only man.
yeah,
Only Maine.
so Maine, but you know, I
No
mean.
protections for Bud Light, by the way.
But I mean, I think you could have a policy that says that you're not gonna hire anyone who smokes tobacco. I mean,
We got
that's-
a policy that says that, but then we also were bound to the Harvard project labor agreement for laborers and other union workers as well. And I'm not really sure what they do in the context of when someone gets sent for a drug test and tests positive for marijuana. Is that considered a positive, or what do you do with those people? Right, because the Harvard Project Labor Agreement says that if they test positive, then they're off the job for a certain amount of time until they can test again. But do you consider marijuana, does the laborers union consider a marijuana test a positive test that triggers that? You know,
That
period of time
triggers-
they can't work, so.
It's hard
Oh.
for project labor.
I think for those tests, then it's not termination, it's referral to rehabilitation. And then back to work, return to duty with follow-up testing.
But say, for example, say a laborer was on an SPS job and tested positive for marijuana, so we discharged them. And even if it was medical marijuana and we still discharged them, would the laborers union make them enter that process? Or if it was, no, this person tested positive, they have certification, we're not considering it a positive test.
Right, and again, something like that with all of these new implications for employers, I think would be probably worked out through a collective bargaining agreement and establishing that substance abuse prevention policy with specific verbiage addressing the medical marijuana. And I think that's, moving forward where things are gonna go with regards to establishment of policies, having specifics with regard to marijuana use, medicinal marijuana.
Right, and the challenge there being, we're not talking about a person who's coming in who's gonna demonstrate, thin and trim meat cutlets. They're gonna show up on a bridge job, I'm here Monday, they're gonna fill out their paperwork with the superintendent, do safety orientation, go directly to work. If they present with a card where they've tested in the last 6 months, great. If not, the following day, they're gonna go get a test, they're gonna come back, work 2 days, we'll get the test result back, and they'll either stay or they'll be discharged. We've had both. And I can tell you, the ones that get discharged, my superintendents and foremen, they all say the same thing. Was one of my best guys, thanks a lot, because it doesn't affect their work. So that's the real challenge, that we're struggling with.
This may be valuable to you guys. So I have this, like I said, I'm in this big law firm, we have a library. And every day, the firm librarian sends me every drug testing case in the country, a little blurb. Okay? You might think, given the Barbudo decision and all the heat and press attention that it generated, that drug testing litigation is frequent. It's not. This surprised even me, right? I love to litigate cases. We had a lot of fun, right? This is fun. I like talking, even though I lost, I like talking about it, and I still hold out hope I'm going to win in the end, right? I like this stuff. It's perverse, but I like it. There is far less drug testing litigation than you would ever imagine, right? Because people are bounced out of jobs all the time. Some of them for taking prescription opiates, right? Now, the EEOC has brought 4 suits around the country since October on prescription drug policy. So you can't ignore it, but I think you could easily overinflate the risk of getting sued. It happens less than you might imagine, if that's valuable to you.
So if they enter into a project labor agreement, That's voluntary, you just don't have to work that job. You're usually union represented, you get your business agent, I can't pass that job, send me somewhere else. So it seems to me, if I'm understanding what you're telling me, the only time that it really applies if you're discriminating on that base, like you're having an unfair advantage, you know. My nephew, who I know smokes weed, I'm getting him through. This guy I don't like, I'm having him take a pee test because I want
Well,
him
that's a
on the
good
job.
point that I raised to clients, right? So as marijuana becomes like alcohol in this country, you had better make sure that you treat the Hispanic laborer the same way you treat the
Everyone who
CFO
walks
who
through that
smoked weed in
turnstile.
Aspen, right? You can't start, allowing one to keep his job and terminating the other.
That's what a project labor agreement
Yep.
does. We all apply to that standard.
Yep, absolutely. I mean, one size has got to fit all. You've got to be fair and non-discriminatory in how you apply a drug testing policy, no question.
I think the trades know that anyway.
And that's, we try to have that discussion, but it's there's nobody
We
on the bench.
just don't send them
There's
there.
nobody
You
on the
can't
bench.
pass the
so-
pee test, you're not going to that job.
Right, there's nobody on the bench, so.
And you would treat those people the same way you treat your workers who are, maybe using opiate pain relievers, Adderall type medications. You would have to treat them the same.
One other thought, this isn't marijuana specific, although it would certainly include marijuana. In October of '16, OSHA came out with some new rules about drug testing. And OSHA determined that certain kinds of post-accident drug testing were discriminatory, or retaliatory, not discriminatory,
That's right.
retaliatory. The employer community went bullshit over this, right? What OSHA is now in support of drug use at work, right? So OSHA backed off and came out with a few examples that are helpful. One of them involves a crane. Okay? So a crane op causes an accident, injures 5 people. If you test the 5 who were injured and not the crane op, that's retaliatory. Okay? If somebody develops carpal tunnel from running a jackhammer and you post-accident test them, that's retaliatory. Why? Because this injury didn't develop one day of running a jackhammer. It's a cumulative chronic injury. You're using the drug test to retaliate against people who bring injury claims. The third example, they said somebody gets a bee sting and you test them. Well, you didn't get the bee sting because you're high. You're testing them perhaps to retaliate against them from filing a first report of injury. So if you avoid those kinds of scenarios, you can avoid this post-accident OSHA retaliation claim. So, test the crane operator who caused the accident, not the victims of the accident. Don't test the bee sting or the chronic repetitive stress injury.
What if you test the crane operator and the victims? Is
I
that
think
considered?
that's a bit of a gray zone, but I could defend you on that.
That's one thing, we look at this as employers, but when you go to work at another facility, powerhouse, industrial campus, whatever, and their rules are, there's an incident, not everybody who's involved in it, but anyone who's potentially exposed, you're all getting tested.
Yeah, we get that a lot.
So,
To come on this site, you have to be tested.
Because
Right.
we've signed into that to be able to do the work.
But it's not technically out of your hands, because when the lawsuit's filed, Matt's gonna sue you and the other company and claim a joint employment theory, and you're both gonna be dragged in, so.
I just came from the site with one of our operators. Our orientation and the drug test and everything else, and he was bull. I said, what time did you get there? 7 o'clock. What time did you start getting paid? 7 o'clock. Why are you bull? It's like some of these construction sites now are exercises. They go out, the program to do
That's
it.
right.
Why do I have to do that? Are they paying you? I'll sit there, $45 an hour. I'll exercise all you want. Really?
But it's quite possible that the company sends this person to a drug test and discriminates against them in a violation of the Barbuda decision. And that puts you in a vice, right? Well, wait a second, you're imposing your drug test that might be discriminatory or improper in a way that impacts me. And I could get dragged into this. I mean, that becomes a negotiation between the two companies, and that's pretty tricky.
Yeah.
Now, one question I had, you said, you believe Colorado has a 0.5.
5 nanograms
Five,
per
sorry.
ml of blood.
5
Right.
ml, and that is of THC?
Correct.
Blood.
Blood.
Blood, wow.
What is, so And that's considered in Colorado
The threshold.
impaired.
For driving, yes.
That was impaired level.
DUI.
Yes.
So, you know, it was talked around, I think you stated some of it with the constant talk about the different strains and different potencies and everything like that. And I think it kind of answers your, I don't know why you're looking at marijuana so funky. If there's a therapeutic dose, has that been determined? Because any of those other drugs, you pop an oxy, there's an amount, that's in the threshold, that comes back in the test within a zone for proper administration of a legal med. With marijuana, it sounds like every step of the way, somebody's saying, I just did my part. I wrote them something, I didn't sell them something. I just sold them things, they paid me money, and the person sitting at home saying, not there yet, and could just keep on toking until they get what they deem a therapeutic dose, and that's an addict.
And that's
Right?
exactly what
That's
happens.
somebody seeking self-medication through some type of drug until they're not worried anymore. And
Right, so,
Wish you'd come to court with me.
Which
So
my
there's
parents
no
always
way-
accused me of wanting to be a lawyer because they argued.
so there's no liability, obviously, to the physician because it's not a prescription, and he's not dispensing it.
Mhm.
And you're absolutely right. Some people, especially chronic users, will continue to use more and more larger amounts of marijuana because they do develop some level of tolerance. So they will seek strains that are more potent and they will use more frequently in order to get that same level of high. And you're absolutely right, there is no consistency because when we talk about pharmaceuticals that are manufactured, right, they're manufactured under standard regulations that ensure that 5 milligrams of Valium is 5 milligrams, right? But with the THC, there's, as I mentioned earlier, there is no consistency in that potency for even a particular strain.
I'll give you the one quick countervailing point, though. I obviously it's hard to generalize because everyone's different, right? But I think that what you're talking about seems to me to more as a stereotype than may be true. I have several clients that I've consulted with me that don't even like it. They don't even really want to take it, but it helps them. Christina would tell you she doesn't enjoy it, but it helps her be healthy. So we can debate probably, till the cows come home about whether it's an effective medication or not. Some people would say yes, some people would say no. I think there's doctors who disagree upon that. But, I will tell you for sure that I have several clients who use it, and it's the only thing that helps them, whether that's for pain, whether that's to keep an appetite, whether that's to sleep. So, yes, you may have people who, like you're saying, with more and more and more because I can, and then you have other people that less and less because they don't even want to do it. It's the only thing that actually helps them. So,
I understand that, and I've seen that in other drugs. I had two parents, a 4-foot-tall mother who, had Darvon prescribed for migraines. My father thought he had a really bad headache one time and thought he tried one of what his little wife, 4-foot-tall wife, when he's 6'5", and he was loopy and said, I never want to do this again, can I get detoxed at the emergency room? And Mom was like, well, so I know the difference in chemistry of a human being can impact the way some of those go. To circle back, the THC is doing both things. It's that initial high that everybody thinks about when they talk about smoking weed, and then we're talking about impairment in the fat cells. It's still THC that's found its way into the fat cells, coming back into the system and creating that long drawn out, or is it two different chemicals?
Well, okay, so it doesn't become the active metabolite of THC until it's processed through the liver.
Okay. So that's the long-term impairment
Right.
metabolized version.
Right.
The pre-metabolized, is that why some of it gives people the euphoric high or the
Well, that's just because
effects
it's
of-
connected, it has
the
connected with the cannabinoid receptors in the brain.
Okay, so the ones that do not get them high are low on cannabinoids,
As far
but
as
still has
strains go,
THC? Yes.
all right, so, right, the indica strains that have more of the cannabidiol, that does not contain the psychoactive component that the Stavia strains contain, which is the THC, which is the psychoactive chemical, right? So depending on which strain you're using based on what your medical condition is, the indica tends to be more for things like insomnia, maybe anxiety. Those don't contain that psychoactive THC component. And so people with those types of problems would use that strain as opposed to the Stevia strain, which contains the THC, the psychoactive, which, yes, has that ability to, provide you with that high, but also, like in Mrs. Barbuto's case, increase appetite and has those therapeutic effects. Yes, at what level? Individual basis, potency of the strain, all variant.
And you had said there was the synthetic version, and that pops positive,
Yes, it does.
equal to, like, in the same category as cannabinoid on the
Wait,
drug test?
Marinol will,
Right.
but like K2 and Spice.
Oh, no, not those.
Those will not. Those are synthetic
Those
pot
are
you can buy at corner
synthetic,
stores.
right, not
Okay.
those.
No.
Those are the ones that people are found naked, like gnawing on each other, covered in
Right, right.
blood.
that turns into-
No, no, not
Those you
those.
don't test positive for.
Mike, don't tell us what you did over the weekend.
Really, that's a real different channel.
Now, the two
So that's the
FDA,
common side of that.
Yeah, that's, why you would do that is sort of beyond me.
Yeah.
so there's the Marinol and the Sesamet, which are the two FDA-approved legal forms, and they are synthetic. So lab, originated, so definitely a certain therapeutic level with those types.
Can I ask you a question on that? Now, this field is wide open. It comes in so many forms now. What about what I hear often is CBD oil without the THC, and it comes in a
Correct.
caplet form?
Right.
Is that tested? Will that trigger a bad test or coming up dirty, if you will? If someone takes that for pain, I know people that take that for pain, it's what
Right.
works.
Yes.
So does that cross the threshold of illegal, having it in your bloodstream or illegal or whatever?
The same as it would
And like smoking
for
a-
smoking.
Smoking any other joint you
Right.
find off the street.
You're just not gonna get the high that you would.
That's what I've heard, that you don't get the high, but it still
Right.
has
It's still a THC derivative, yes,
the derivative, okay.
right,
Going to show up in a test.
right.
It's gonna show up in the test,
Right.
yeah, it's searching for the right way to phrase that.
So you're
We have a
not
hard time
hearing-
teasing that out in real practice. If somebody comes forward and tells you that they use a non-THC based skin cream,
Right, they come in topicals.
in the marijuana card, it doesn't say buy non-THC skin cream, it says you can buy marijuana products. You go to a retailer and you pay cash and you get whatever you paid cash for. And as a matter of proof, it's gonna be very hard for you to determine and to prove what they did or didn't do. All these sort of unanswered questions out of the Barbuto decision, representing employers for my whole career, I knew were gonna be frustrating, and I tried my best to have the decision come out the other way, of course, and now we just have to live with this and to try to muddle through this stuff. I mean, I have a whole slide deck on the conundrums, and that, next time I do it, that's going in there, right? Because you've got non-THC based products that will pop positive. All you get is X nanograms per milliliter in urine. You don't know if they were smoking a joint, eating a gummy, or using a non-THC based
Right.
cream.
Well, for a while there, we didn't know if they were eating poppy seed bagels either, but, you know.
So Matt, if you were representing Miss Barbuto and she was a carpenter and worked on scaffold, how do you think you'd ended up?
I'm gonna give one of those frustrating answers, which is probably, I don't know. it would not be as strong a case as the one that I had, because I think we have very good facts. But I don't know that it's I don't think it's a non-starter either, you know? I think it's more complicated, but I don't know the answer.
I think you need to assess what your positions are that are safety sensitive and which employees are gonna fill those.
And we have that in place, but again, this is something that's new that's coming at us, and if every prescription says, here you go get what you want, treat it as you want, it's gonna be a challenge, you know? Until somebody comes up with that test that says, yep, you're under the influence right now.
Similar on that, to drill down on that idea of being impaired, again, with the only one saying that 5 milligrams. There are, I thought, you know, and I could be wrong, but tickets being issued similar to DUI, but driving while impaired. That's based off of a police officer's reasonable suspicion. Has any of that started to go to any legal proceedings to say, prove I was impaired? Like, if only one state has set the bar at that .5.
No, there hasn't been only one state, there are numerous states. I think Arizona and Utah have 5 as their per se limit, and without any other implications, like, that's it, 5, and you don't have to provide me with any other proof.
That's DUI.
Right, and I think Nevada is 2.
But the key is getting to an impairment level, like
Right.
an impairment versus a therapeutic dose, what should be in the stream, you know, if you can defend yourself at 5. you
Right,
know.
and I'm sure there have been cases with regard to that. But
You're saying
not-
where you're both taking a therapeutic dose, but also maybe approaching the limit of impairment?
Right.
Like there may be
you
some
know,
cross-section there at some point.
And again, I know that the frustration is that saying it's a class 1, so we haven't been allowed to test and figure that out or anything to that effect. I mean, 8 years ago, I was at a presentation where they said they could pull that THC out of the marijuana, put it in a capsule, and now you're taking X number of milligrams per pill, and they can start adjusting the dose. Someday, when all that frees up and you can test and do some medical testing, I don't.
Well, I went into a dispensary, I was in Denver for work, and there was a dispensary right across from my hotel, so I went in.
Oh, sure, research.
It was interesting because I had taken the position in conferences like this that you couldn't tell the dosing. And that's absolutely true with the smokable bud. But the gummies that they sold, and there was an energy drink, the gummies were 80 milligrams of THC per gummy, and the energy drink was 100 milligrams of THC per bottle. Now, I don't know if that's accurate, it's probably not FDA regulated like a capsule of you know, whatever. But I was surprised to see milligram dosing on the packaging.
Yeah.
I thought, oh, okay. You know, I wouldn't know if 80 milligram, I wouldn't know if that gummy is a mild buzz or would have me on my ass. But it was there, and I thought, okay, I'm gonna have to actually adjust what I say, because I had said that there was no dosing at all. I think that's true for the bud.
Or it is.
And
What did it do to you?
When it's biological, it's growing.
I never took that gummy. You're
I
on.
can't prove I took that.
There's no addition in his office.
Yeah, I'm not safety sensitive. But, so it does exist, and maybe we're going there. I mean, I think the developments are gonna be big. It was an article in the New York Times last Sunday. A bunch of doctors have gotten together and asked that it be removed from Schedule I so it can be researched. They're gonna make $1 billion a year in tax revenue in California on a 15% tax rate for recreational. Now, if you're a governor of a non-recreational marijuana state, you know, every state is scraping by police and fire and teachers and potholes. $1 billion of revenue off dope. Give me some of that. So this isn't going away, and I hope that we will get answers to those questions. I think we will. In the meantime, you just got to be conservative and safety conscious and do your best to muddle through. Like that Boston Scientific example, that's why I give it. You know, you have, as Matt says, you have no protection for recreational. A lot of people say, I use it medically. I never really got around getting the card, though. Well, that guy didn't have protection. You're gone.
I skipped that.
Yeah, I skipped the whole card. Okay, no protection.
Self-diagnosing.
Yeah, self-diagnosis, self-medication. You know, if you, to find, there's really a pretty narrow avenue to what is job protected. Can't be high at work, maybe you, maybe not possess at work, but you can't use at work. You have to have a valid card, non-safety sensitive. Every time you take one of those, you get to a smaller slice of your workforce. You may end up in this difficult decision, and then if you are, you do this interactive process, sit them down, talk to them, try to get their doctor, HIPAA releases, right? Maybe they bow out in the middle like that Boston Scientific sterility control guy says, whoa, I don't need this trouble. I'll take another med. Whew, okay. Right? Maybe they finally put you on the horns of a dilemma. If you pull the job offer, you can say to the judge, which I couldn't say, we did this, 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 and we finally decided we couldn't take the safety risk because they're working at heights.
Yeah.
Okay, I would have loved those facts.
The takeaway for me, and this is the one thing that I don't know, maybe it needs to be fixed at the state level here in Massachusetts. So I hire a crane operator who's going to go to work, and you know, I've heard this parable time and time and time again. I don't care what you do in your off hours, as long as you're not doing it while you're at work. Well, now with the knowledge that there's a potential impairment that's going to carry forward for 4 days, we need protection. As an employer, we need some kind of protection. We need to protect ourselves against that.
My only issue with that, Jay, and I don't want to be redundant. I think it's very valid what you're saying, but again, I don't think that's marijuana specific. I think,
No, it's
you know,
not.
if you're gonna go to that, if you're concerned about that, then you need to expand the list of what you're concerned about.
Yeah.
And you need to look at opioids, and you need to look at depression and anxiety and ADHD and insomnia and many other things that a lot of your employees are probably dealing with, or the general public is dealing with. And look to see what the length of time and impairment for that.
Right.
So I'm not advising you against it, but I don't think it's fair to single out marijuana in any real. I just don't see why. Why are we doing that?
Well, we singled out alcohol, right?
Mhm.
We actually have a go, no-go on alcohol. We have a DUI level. We're in a business that can be run very unsafely. You know, we make national news when a crane goes down. We make national news. So, you know, we have to be, and it's not about the news. It's about the safety.
No, I know. But I'm just saying, if you're gonna, I think it's short-sighted to say, okay, well now all of a sudden we have to be really concerned about A. You should be concerned about A through Z.
I agree. But I think maybe we have to pick away at that list. Now that we've brought, face it, marijuana is a big topic. Opioids are also a big topic, and maybe our next roundtable actually. We're already talking. I think picking away at the list, I mean, we've encountered, Cranes 101 has already encountered a problem with marijuana specifically. You know, so we're sensitive to it. And yeah, maybe that's it. Maybe we have to pick through the list.
Well, you know, I appreciate your statement, but sitting here thinking about it, I don't have to go rewrite a thing at my company, okay? What's medically covered is still medically covered if there's a script and there's a medical reason and rationale behind it. What's illegal is still illegal, and the rules are still in there about impairment at work. We've written it, we put it by our lawyers. It's pretty sound, but, you know, then there's just all that different, it's new, So what does somebody impaired look like, you know? Again, that's why I was asking a little bit about the THC, whether it was the stuff that made you high and get the munchies, or, just was that impairment over the long term. Not everybody's gonna walk away seeming like they just came out of stoner high. Not everybody's carrying a surfboard just because they toked up, or because they ate the edibles. That is a good point. That it'd be good once we get to a point where it can look like any other medicine. When it's being smoked, when it's in a biological state, when the sun, the moon, the stars, and the rain levels are all going to make it fluctuate. That is that uncertainty that makes you nervous.
Yeah, no, I get that.
I think, to your point, Jay, it's, since we have now made it legal in 30 states, and for the most part, consider it to be medicine, right? Not under the federal law, that all of those implications that, you're concerned with, all arise from those 2 points. That it has been made legal, it's been made legal quickly, basically for the tax revenue that it brings in. Most state legislators, have approved it just on that. I think Colorado got like $110 million for their school department. And so those kind of contribute to, I think, how quickly it's happened. It contributes to your concerns. And the fact that it's, now legal, right? So again, treat it as you would the rest of your drug panel, especially with, your, randoms, be it nuclear regulatory, your safety sensitive positions, just treat it the same way. And obviously consult with your legal counsel.
I mean, listen to this right out of the decision, okay? Our conclusion that an employee's use of medical marijuana under these circumstances is not facially unreasonable means that underlying case must be reversed. Quote, but it does not necessarily mean that the employee will prevail in proving handicap discrimination. The defendants at summary judgment or trial may offer evidence to meet their burden to show that the plaintiff's use of medical marijuana is not a reasonable accommodation because it would impose an undue hardship on the defendant's business. And they give 2 examples of what the hardship would be. For instance, an employer might prove that the continued use of medical marijuana would impair the employee's performance of her work. That's in there, or your ability to perform its business. Perhaps Advantage Sales and Marketing had a contract with Stop and Shop, that Stop and Shop required ASM to drug test its people. Boom. So I've got plenty of room to argue, and all these things will be filtered through subsequent decisions, and we'll get more facts and more decisions, and trial judges telling us what this really means.
Well, I
There's
gotta
stuff
tell you,
here.
and all right, I'm gonna open this up. I did smoke weed in the 60s.
I smoked it in the 90s.
We just ran into scenario 3. We lost a very large contract with a company. We had 2 trainers out in Ohio doing training, and we were told after they commenced the training and after we'd already spent all the money to get them out there and get all the stuff out there, they did a day of training, then they said, we have to drug test your 2 employees. And they did. And we never in our lives expected that these guys smoked pot, but found out after the test that they did, and we lost the contract. Now, as Maria and I had discussed, and many others, what are we legally capable of doing? Now, we don't want to lose these employees because now we find, like everybody else, if we got rid of everybody that smoked pot, we'd have nobody left to work there. So are we our trainers, we're not worried about safety. With our trainers, that they carry a computer, a pen, and a pencil, and that's it, they're not running heavy equipment.
You're looking for a policy?
Yeah, what are our limitations, can we ask, that when we go to hire somebody to pass the drug test, or make it a condition of the employment, or make it a condition of the employment of new hires would be discriminatory against the existing trainers, wouldn't it?
I would argue you could test them as safety sensitive because they're training people, even though they're only using a pencil and a laptop. That might be a reach, but I don't think so. I think there's still serious safety implications with training people to be cranked. And that they put your contract at jeopardy, and in fact, they did. They lost the contract.
Yes.
So drug testing that person and bouncing them for medical marijuana in mass, I think I can defend that case successfully.
So the rules here, it's about as clear as mud now.
Well, we straighten that out.
I think this is fascinating, actually. It's a dynamic that continues to shift. And we don't have solid things, but what I'm taking away from today is err on the side of safety, have a company policy that everyone is subjected, apply it equally, and get the dialogue going. When someone isn't having a problem, dialogue should be your first option, not throw them out the door. And then you can prove that, look, we're working with this. It's new to everyone. We don't have anything hard and fast yet. Let's address the problem
And
as
you
we
could be
see
having
it.
that dialogue 6 months from now, right? This may happen a year from now. By then, there may be 2 more decisions that help you, right? Or that hurt you, but you get to know what they are. You're doing that in the context of somebody's real medical problem.
Right.
Maybe you get a doctor to answer some questions, you put those facts in the mix. I think you're right on.
But I think the discussion has to be a legitimate, genuine discussion.
Right.
I mean, I could easily attack a discussion that seems very superficial and you're just doing it because you have to and some attorney told you to, so you're going to have the discussion, but it's sort of meaningless. I think it has to be a real discussion, a legitimate analysis and discussion, not just this check a box that you did it.
Well, yeah, unfortunately, that's kind of what happens sometimes, but realistically, this is all new to all of us, and so we're going to continue to move through it.
For the doctor, would Mucinex D show up in a drug? And I'll tell you why, because I fly a lot, and naturally, I get on a plane, I come home with a cold,
Yep.
and give it to my wife, because it's the gift that keeps on giving, but will that show up? Because I had to go get Mucinex D, I think it was. It's the one that's behind the counter. That you had to sign for.
Oh, okay, so.
Is that?
It came back positive for
I
amphetamine?
was asking if it would.
If it would.
Oh, okay.
I don't know
so-
if it would.
It depends. Sometimes if it has a decongestant in it, the pseudoephedrine could cause the cup test to be falsely positive.
Okay.
But again, would not be positive on the
Yeah.
split sample. Right, so that's a problem with the decongestants.
Yeah.
It's probably the eye cup too. Those cups are,
Yeah, and it depends on the cup and, specificity and sensitivity of the manufacturer. So definitely.
I'm curious to Adam and Mike. This all started essentially pre-employment. She went to work one day, test came back positive. She was let go. She initially sued, I assume, to get her job back or to get compensation for, or neither? Was it just based on the discrimination?
No, definitely not neither. Arguably both.
Okay. So in that
Probably,
timeframe,
probably the later we moved into the process,
has she
probably.
ever gone back to work for that company?
No.
Has she found gainful employment somewhere else?
Yes.
this was a 16-hour-a-week, $10 an hour job, by the way. This thing has so much hang time.
Right, you're talking about $100,000 that your client has spent with you, just to kind of essentially say we were in the right to not employ her because she was a drug user. What is when you guys go into settlement, what are you trying to achieve?
It's a good question. What are you trying to achieve?
And the reason I ask is.
You want to
I'll
mediate
throw
this
those
case?
cards.
Yeah,
Don't show 'em the cards.
you know, I obviously can't, in this
That's
forum,
not the
get
right
into it.
question.
I mean, at this point, though, compensation.
Yeah,
And we're gonna have to try to arrive at a figure, which is why we're going to mediation. It's a
right,
formal process.
yeah.
We're gonna spend a half a day or a day there. We're gonna try to iron this out.
Yeah. The reason I
It comes
ask-
out, yeah, it'll come down to some sort of monetary figure that everyone, that everyone can live with, right? Most mediations, in most settlements, no one's happy. The person bringing the case always feels like they should have gotten more. The
Yeah.
person paying always feel like they paid more than they wanted to.
Right.
That's a good settlement. If one side is thrilled, something went wrong, because if the company's thrilled, it's probably not a number that the employee is gonna accept.
If you
If
both
the
think it's
employee's
a bad
jumping for
deal,
joy,
it's
the
a
company's not gonna, you know what I mean?
Yeah.
At this point, that's probably where, she's not gonna go back and work. I mean, I think that ship has
The
sailed.
reason I ask is our company is dealing with a back injury situation unrelated to marijuana, but I can see this someday being an issue. And I'd say the lesson I've learned from is immediately have the discussion. Don't just say, well, this is our policy, this is the way we're gonna do it, so. But regarding recreation.
Were they hurt at work, or nothing to do with being hurt at work?
No, it had to do, but it's a year and a half we've been going on with this guy.
Okay.
So again, I can just kind of see parallels to what you guys are dealing with, because this happened, over a year ago with your case?
Oh, yeah.
Oh, yeah, I mean, cases, I mean, litigation can go for several years, so, yeah. that's-
But
Documentation.
if we have a policy that says, all right, you can't use, alcohol or marijuana, and you can't use any drugs that are going to impair you while at work. But if we have a laissez-faire, what you do on the weekend is fine, as long as you don't come into work hungover or still stoned or what have you.
Who's the judge?
Right, that's the other thing.
You know?
Well, you can get some training on that. I'm not gonna recommend any training vendors, because
Yeah.
I haven't gone through it myself to know. But there are training vendors who will help you and your people spot intoxication. I think that's money well spent, I really do. It's not, especially with things that aren't marijuana or alcohol, it's not obvious. And supervisors are particularly uncomfortable with ratting somebody out, sending me in a cup, I get that too. So, giving them some training is a good idea, especially if you're in a safety-sensitive situation and you have the policy like you do, which is you can do what you want on the weekend as long as you show up sober. Well, you better make sure that somebody's able to determine what sobriety is.
Yeah.
That training I would recommend it.
And again, it's like the drugs, you build up a tolerance to, my buddy owns a company, and one of the guys there drank vodka in nips, and you couldn't smell it off him or anything else, but he used to throw the things behind this wall. Well, 2 years after he was there, they decided to remodel it, they opened up the wall and they couldn't believe it, but they couldn't smell it off him, and again, he was built up a tolerance, because yourself, I mean, some people go out and have 20 beers and be fine. My wife has a second glass of wine, and it's, almost ready for the divorce court. Remember last year? Just one glass of wine, honey, please.
Anything else? Yes.
We might have already kind of touched upon this, but I just want to be clear. The discussion that we're having is really centered around somebody who has a Massachusetts medical marijuana card, not somebody who fails a drug test, who does not have a medical marijuana card. They could still be subject to a company's drug testing policy.
Zero tolerance.
They could still be zero tolerance. Has there been any ruling around colleges around that? For example, I work with one of the local colleges, and they have been wrestling with this issue in terms of smoking in the dorms. So wrestling either with students who have medical marijuana cards, but a lot of students who don't, who are smoking, and how to offer them treatment, and at what point does zero tolerance apply, because they fall under the Department of Education, which is a federal agency, right? It's federal standard. Has there been any rulings around that, or at the beginning?
That's so outside of my area, I can't weigh in.
Topic.
Yeah, it's a bit outside of mine as well.
I read that if the university solicits federal funds, they have to go by federal policy.
Yeah, that's what, yeah. I was wondering if you heard anything different, since this case has sort of brought up sort of a new light and way to look at some of those federal.
Yeah, I mean, this is what you're talking about is not an employment situation.
No.
Are you asking whether the college can expel someone essentially?
Yeah, yeah.
I know most of the campuses, if they're declared smoke-free, then obviously
Then it's smoke, yeah.
that means all kinds of smoking.
Vaping.
Yeah.
Vaping,
Well, that's the thing,
right,
vaping,
so,
I-
right, and so, I think in most instances, they would, kind of assume that means they're marijuana smoking as well, but I don't know that there's been any kind of,
Specific.
Right.
A new rule.
like, no.
There's gotta be some type of policies, I would think. In our town, they built an apartment building.
Which is
And I'm
smoke-free.
driving down the street and I saw people standing, and there's no bus that goes by this place. And what are they doing? They're smoking because they're not allowed to smoke in
That's
the
right.
park.
Yeah.
That's right, so, and again, that varies by not just state, but city ordinances as well.
And again, probably that might have had something to do with federal money.
It
More
may
than
have,
likely,
if
so that
it's
might have been
a,
in the policy, I don't know.
absolutely.
Yeah.
And if you believe that your, employees are maybe vaping while at work, then again, that's something else you should put into your policy as far as adding it to your smoke-free workplace
Yeah.
policy.
Can I just get the question? Her question was a good one. I'm sorry to refer to you as her.
That's okay.
But, and I want to make sure I understood the answer right. If you don't have a medical marijuana card, you can implement a zero policy. That
There's
was
no
lost on me,
protection
actually.
for
Correct that
That's
up.
right.
No protection for no job protection for recreational pot, period. Except in Maine.
I want to say that the governor of Maine did veto,
Yeah, Governor Page.
yeah, he did veto the recreational
Well, he's vetoed
marijuana.
it, but I think their
And that was like
legislative
November.
bodies can override him.
Yeah,
The law itself had this anti-discrimination provision on recreational weed, which was just
Yeah.
astounding to us.
right. I think when it came to him on, like, right around November 4th or 5th, he vetoed it.
Yes.
And I don't know what happened since then.
I haven't heard anything either.
I just want to clarify your clarification. So, and Mike, help, tell me if I'm wrong here. So you, if someone does not have the card, then they can use it legally, recreationally, but that does not give them any job protection. That's what you're asking?
That is one of
That, so I agree with that, but there's also, and your question was also specific to marijuana then, right?
Yeah.
Okay.
Because
Because there are
that's the new
other,
game now. I mean, it's the new outfit in the room.
right? You see where I'm going though? Like, you can, people can have other medical conditions
Well, then let's
where
just
they
say
require
drug.
medication that they don't have a card for,
But I
and they
think
might
you know
test
that,
positive,
right?
but
Like opiates,
you already
you
knew
know
that,
that.
right.
This is the new one that we
Yes.
it's muddy.
Yes, so you're right, and that's why I think Mike's point was, people think that there's this explosion, but there's of cases, but actually not really, because you really have to fit under a pretty specific set of facts, right?
Right.
Not recreational, yes medicinal, yes with the card,
Right.
not using on-site, not impaired.
Well, there's
So
a
we're
feeling-
narrowing this down to a
Right.
fairly,
There's a feeling out there that that they can't come after you for that anymore. I hear it among the younger employees. It's all changed now. I'm thinking, well, I don't really think it's all changed now. I mean, it is changing. That's why we're sitting here discussing it, but it's not. Everyone doesn't get a pass now.
no.
There are many under that impression. Younger people who are generally probably still smoking weed.
You can disabuse them of that.
I have,
notion.
this might be a good way to end, because I know people are, I have 3 teenagers, and everybody's talking about what they did in the 60s and 70s and everything else. So if you guys have kids, and you mentioned this, but this is worth thinking about. I certainly talk to my kids about this. This is in this article, okay? When use begins in adolescence, the effects are far more likely to be long-lasting or permanent. Repetitive use of marijuana during the teen years is associated with a 6 to 8 point decline in IQ.
I read
don't know
that.
about you guys, I need every point I've got. Okay? And then it goes on. Lower IQ scores among adolescent onset marijuana users have been measured for at least a full year after complete cessation of usage. Whoa! Okay? So the idea that this is just pot, I did it in the 60s, 70s, 80s, 90s, whatever the hell it was, right? I think this pot is by orders of magnitude stronger than the pot that was
Way
done in the 60s,
stronger than
70s,
what
80s.
we would.
And this is scary, okay? So I said to my kids, they know I'm the drug testing practice group leader, they probably
Your kids don't have a chance.
So we were at dinner and I said,
They come home a lot and pee.
yeah, they drink a lot of water, it's fine.
Look out.
But I said to them, I said, all your friends' parents are gonna tell you, don't ever start, don't ever try it, I'm gonna tell you why. And I said, here's this stuff, right? This is real. And my son said, well, it's legal now, right? Okay? And he's right, it is legal now. Okay, but that doesn't make it safe, right? Cigarettes are legal, and that's a terrible thing to start.
Right.
You're gonna smoke for 2 years, and you're gonna spend the rest 32 years wishing you never started. Okay, and so there's stuff in here for moms and dads too, which is like you go home to your kids and you're like, hey, this is real stuff, and smoking in the adolescent brain is a really bad idea. And a 6 to 8 point, I don't know how many IQ points do people have, 110, whatever. That's 3, 4, 5%. Whoa.
Unless you're Einstein and look.
Yeah, right, and then it's 2%,
Yeah.
right? Still, it's scary. So there's stuff in here for a lot of reasons, and a lot of them have nothing to do with work, but that would make good read and something to pay attention to.
Right, and those are IQ points that you can't ever make those up.
Right.
They're lost and that's it.
It is a,
Kind of a weird one, and I don't want to litigate your case or anything like that. But when it's still illegal federally, why isn't it just said, well, we have, we always have that out to go to the federal courts and say, well, you judge on it. Oh, it's illegal federally, so any of these debates on states' rights as to how they're going to legislate something that's still illegal on the federal level.
Massachusetts has its own anti-discrimination provision, Chapter 151B that Matt mentioned, right? So if this case had been brought under the Americans with Disabilities Act, the federal anti-discrimination law, we would have had that argument. It was brought under the state anti-discrimination law, which was smart, and he says the other cases weren't brought as disability discrimination cases. He brought the right case in the right state in front of the right bench. And California, very liberal. California has the Fair Employment Housing Act. Some creative lawyer, well, it won't be half as creative as they were because they did it first. Some creative lawyer in California is going to rebring the FEHA case and say, my client has the right to protection from disability discrimination. Medical marijuana is for their disability, and you use the same theory. But it's confusing to say the least, to think about state law, federal law, federal court. Jeff Sessions versus Eric Holder, good God, it makes your head pop.
Yeah, I mean, it's,
But I mean,
What he said.
quite honestly,
I alluded to it before.
the conversation
Right.
has brought it back to a degree where I'm kind of bummed out, being that we do federal contracts. I thought that was like a hot knife through butter and say, can't have it, done, right?
Well, that's
You know,
an
but
argument.
if
The Drug-Free
one can
Workplace
say,
Act.
because we exist and do commerce in mass, there's gonna be that point where we can say, well, I can't say that about my secretary, my admin, my people who are not safety-sensitive positions on the job site that's getting federal money because it's so diluted by the time it gets back and pays admin fees. We could say that person's not the admin for the job and call it accommodated and have to suck it up. So it, like we said, the
Get
term
a
money.
good lawyer who knows this stuff, and when it comes up, call him or her and get the best answer you can get with the state of the case law at that moment. This is moving as fast as anything in employment law.
Yeah.
In many other areas, you can learn it and you can be pretty competent for a while. Here, boy, you gotta stay on top of this monthly, if not more often. So just have somebody you rely on to call and say, hey, my admin just popped positive for pot. I'm a federal contractor. Help.
How does this affect me?
Yeah, and have somebody, run the traps.
Yeah, it's gonna be a case-by-case specific thing. I mean, the macro answer to your question, though, is that, we have state laws that are applicable to our state. The Massachusetts minimum wage, there's a federal minimum wage. The Massachusetts minimum wage is higher.
Right, I think of it almost in terms of
You can't
OSHA being
pay.
a safety person. OSHA says you can do federal OSHA, or you can do a state plan, but your state plan has to meet or exceed OSHA, right?
Yeah.
This is a clear case in my head where I'm saying, the federal law says no, and the state law says, we're gonna use it like this. And it's kinda like, that seems weird, that just wasn't said, and on the flip side, I guess, reality is, well, sometimes they're gonna come in on it if it's busted by the FBI or the DEA coming in and taking your drugs, you're going to federal court, and you're gonna go to the slammer. In Massachusetts, they might have been like, oh, wait, they're good. They're good here, right? So it depends on who actually comes through to catch somebody doing
The feds are not kicking down anybody's door to arrest medical marijuana users.
I think they got some other high-profile stuff.
Eric Holder was specific about that. They call it the Holder memo. Jeff Sessions is much more anti-marijuana, and we'll see if that drives some unique federal crackdown. But I think with California and other states raising so much revenue, it's going to have major pushback if they do that, and we'll see what happens. But if you want it to get more complicated, picture yourself as a medical dispensary or a grow operation. They can't even bank because banks are federally chartered. So a lot of these places are paying their employees with cash.
I saw that.
It's nuts. This will sort out. We'll be on this train together.
Yeah.
All right.
Great.
Thanks, guys.
Thank you.
Thank you.
Very informative, appreciate it.
I'd like to give you each a gift on behalf of us at page 101.
All right.
Sir Crane?
There might be,
Thank you, Chad.